May I please, Your Lordship? With the consent of other side, Lordship, I beg to mention item number 36. Here, Lordship, I have received part instruction, Lordship. We have to file our affidavit, Lordship. Let it come after 3 weeks, Lordship.
Kindly please the matter, Lordship.
You are the
I am
petition.
for, yes, Lordship.
Any objection?
No, Lordship.
In item 36, as prayed for by Mr. S.S. Roy,
Lordship.
Learned Counsel,
State Council, for respondent number
Learned
3.
State Council, with consent from the other side, list this matter after 2 weeks on a date to be
3
fixed
weeks, Lordship.
by the registry to enable the state respondent to file their return in the
Lordship.
matter. 3 weeks.
Oblige.
May it please the Lordship. Lordship, I am praying for listing of a matter on 25th, Your Lordship. The
Any
pensionary benefit
prayer, any
matter.
prayer for listing, please give it to my bench clerk.
Lordship.
It's item number 48. It was wrongly posted.
Item number?
48.
Yes.
5227. Actually,
It has
as
been-
ordered at 160924.
It has been wrongly posted for admission.
Yes.
It should be,
270903.
no, it should be posted for what?
For dismissal hearing.
All right, you wait for your turn. Yes, because I'll have to open the file to see. So wait for your turn. Yes.
May I please, my lord? I beg to mention item number 26, my lord. In this matter, we would like to file an additional affidavit. So kindly matter may be adjourned today, my lord.
You are for,
I am for the petitioner.
as prayed for by Mr.
C. Sharma.
C. Sharma, Learned Counsel, for the petitioner, list this matter after
Who's the vacation?
3 weeks on a date to be fixed by the registry to enable the petitioner to file an additional affidavit in the matter.
Highly obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 55 of the daily list. Your Lordship, in this matter, we have filed our reply to the IA. Your Lordship, may kindly allow us to call for its record. Item number 55.
Yes, you have filed your.
Reply to the IA.
So what do you want?
Kindly allow us to call for its records.
Huh?
Requisition, Your Lordship.
You want the affidavit to be called for.
Yes, Lordship.
Yes.
Obliged, Lordship.
Why is such a long prayer? Simply say call for the affidavit. Yes.
Obliged, Lordship.
Call query by affidavit file course.
May it please, Your Lordship.
Contempt,
Lordship. This contempt
which is the order,
page 13, Lordship.
page 13. Operating portion,
It's Lordship, page number 20.
21.
20, paragraph 21. 21, 22, and 23, Lordship.
Not done.
No, Lordship. We filed our forwarding letter and also reminder, Lordship.
All right. Heard MS
R. Deca.
R.
Deca.
Deca, Learned Counsel, for the petitioner. Stop. This is an application under section 11 and 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India and Rule 9 of the Contempt of Court within bracket Guwahati High Court Rules 2015, bringing notice of the alleged willful and deliberate violation of the order dated 6/6/2024 passed by this court in WPC number 4879 of 2020. Issue notice returnable 4 weeks. Steps by registered post AD within a period of 3 days from today. List after 4 weeks on a date to be fixed by the registry.
Okay.
Yes.
Lordship, on the last occasion, instruction was sought from the department.
Lordship. So you received the instruction, Lordship. Lordship, this is a matter that. Lordship,
Yes.
Lordship, may kindly come to page number 20 of the petition, Lordship.
20.
Annexure 2, page number 19. The related parties, relevant parties 20, Lordship.
Yes.
It is to be mentioned that during your service, if any selection procedure is conducted against the said post by the government as per guidelines, then you will be removed from the said post. You have selected purely on temporary basis.
So
to
here
offer
you have a case that the petitioner has violated the provisions of the guideline.
No, Lordship. Lordship, the petitioner was purely appointed on
Temporary.
a temporary basis, and subsequently the advertisement was called for, and after the due process, a selection was done, and the respondent number. Lordship, 6 has been selected, Lordship, and she has been appointed also, and she has joined also.
She has joined.
Lordship.
Then Mr. Sattar will issue notice, let the instructions be filed by way of an affidavit. All right, you file an affidavit. Heard Mr. A.T. Sarkar, Learned Counsel for the petitioner. Stop. Also heard
8 Talukdar.
MS 8 Talukdar, Learned Government Advocate for the state of Assam. Stop. In terms of the order dated 9/9/2024, MS 8 Learned Government Advocate has received the instruction as called for. And the same has been placed before this court. Upon perusing the same, this court is of the opinion that this matter is required, that notice is required to be issued, and the instructions so placed be filed by way of return. Accordingly, let notice be issued, returnable 3 weeks. You are accepting notice for?
1 to 5, Lordship.
Since MS8 Talukdar accepts notice on behalf of respondent number 1 to 5, no formal notice, registered post AD in respect of 6, list after 3 weeks on a date to be fixed by the registrar.
Deeply obliged, Lordship.
Yes, Mr. Kotoki?
Yes, Your Lordship, this petitioner was placed under suspension way back on 31/10/2022.
Suspension when?
31/10/2022.
31/10/22.
22, my lord. Yes, my lord.
22.
Yes, my lord.
And charge sheet?
The charge sheet, the
It was on time.
It was on none. It was after more than 3 months, my lord. So cause notice was issued. That is on 3/4/23, my lord. Page 21, my lord. 3/4/23, my lord. Beyond 90 days, my lord. Because the principle of 167.
Without extension.
Now what happened? Extension has been granted, my lord.
After the show cause notice issued on 3/4/23, then what happened?
They have given extension on regular basis, my lord.
They have?
They have
been
given extension.
extending.
Yes, my lord. But only cryptic order has been passed all along, my lord.
What are you challenging, Mr. Kotoki, here?
I am telling the order of suspension because there was because the order of extension, if your lordship sees, they only passed a cryptic order that it was because of the gravity of the offence.
Where are those orders?
That I am enclosing. I have copied. Your lordship, the last order that is page 42, my lord. Page 42, your lordship will find. Joint Secretary was placed under suspended effect for 29/10/2022, my lord.
Kotoki, the order at least speaks. There are so many cases where no extensions are also given.
Yeah, I understand, my lord.
Two cases, one case I think Mr. Chaudhary had argued yesterday. Here at least the order talks about the gravity and the seriousness of the offence.
What gravity will what?
Now, how can this court under Article 226 go
Your
into
lordship,
all
I
these
see, my
questions?
lord. First of all, my first submission with your lordship, my lord.
All right, then notice. Let them file because I don't feel.
No, your lord.
Otherwise, I was thinking of disposing it off. But how can this court act like an appellate authority
I understand, my lord.
and review and reappreciate, appreciate
I'm not coming to that. First of all,
reasons
your
given in
lordship,
the
kindly see that.
extension?
Your lordship, kindly see one.
Yes,
thing.
yes.
Yes. First of all, the show cause notice was issued on 31.
That's all right, Mr. Kotoki. You are only challenging the suspension.
Now, what has happened? Now, department proceedings show cause notice was issued. Enquiry officer was appointed, my lord. Nothing was done for last 1 year. There was kept pending. No examination of witnesses.
Do you want a disposal by saying that the disciplinary proceedings?
No, I'm not trying, but why they are keeping this
No,
suspension?
what I'm saying is that I can dispose it off if you both concede by giving a time frame within which the disciplinary proceeding has to be completed. If you want, I can
That
dispose it
no,
of
but
with
because
that.
basically I base was because there are Supreme
All
Court
right, then notice.
because we are there are Supreme Court decision, my lord. You are
Sorry.
also
Heard Mr. P. Kotoki, learned counsel for the petitioner. Stop. Also heard MS M. Bhattacharjee, learned senior, senior.
Here only, and Lordship,
Your
one more
designation is senior,
additional senior.
additional
Senior.
senior governor.
Lordship, one more thing, Lordship. Here they
Ms.
have
Bhattacharjee, I'm only issuing notice.
no notice. That's why, Lordship. They have made only one respondent as party. Here, the state of Assam represented by the Department of Personnel, who is
Department of Secretary, Department of Parliament.
Lordship. No secretary, nothing is mentioned, Lordship. How it can
That
be?
you, in the meantime, Mr. Kotoki, you
Yeah,
have
I
a
will.
look at it. If anything is to be done, you file an
Yeah,
application.
yes, that can be done. That was missed out.
By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the suspension orders dated 31/10/2022, as well as the subsequent orders dated suspension order dated 31/10/2022, as well as subsequent orders dated 2/2/23, 26/4/2023, 3/8/2023, 25/10/2024, 19/2/2024, and 15/5/2024. Issue notice returnable 2 weeks. Returnable 2 weeks. MS so and so accepts notice on behalf of the respondent. No formal notice. List after 2 weeks on a date to be fixed by the registry.
Because orders are you also cryptic order, my lord. So one line order, my lord.
Though Mr. P. Kotoki, learned counsel, in support of his interim prayer, have drawn the attention, have contended that the extensions granted in the case, and specifically by showing the order dated 15th May 2024, that the order is of a cryptic nature, comma, this court, upon perusing the same, prima facie is of the opinion that the reasons have been stated in the said order, and therefore the prayer for interim relief at this stage is rejected.
Your lordship, interim, your lordship, better to issue notice, my lord.
Yes. Verification of recruitment constable.
Yes. But the similar cases, well, this honorable court has already issued notice that was pending.
Notice.
Yes.
Notice I will issue.
In the meanwhile, my lord, the credential of the petitioner may be verified, my lord. If he'll
Sure. Similar order?
yes.
This is your Mr.
R. Islam, my lord.
R. Islam. Heard Mr. R. Islam, learned counsel for the petitioner. Stop. Also heard MS
8 allocated.
A. Talukdar, learned counsel for the
Respond number except 2.
For
1,
res-
3, 4, 5, and 6.
correspondent numbers 1,
3, 4,
3.
5, and 6.
1, 3,
3, 4,
4, 5, and 6.
and 6.
By way of this petition, under Article 226 of the Constitution of India, the petitioner is a petitioner is canvassing his grievance that the appropriate marks have not been given to him in the recruitment process for filling up of 145 numbers of post of constable within bracket GD in the Assam Industrial Security Force AISF. Stop. Mr. Islam produces an order of this court dated 31/8/2024, wherein in a case of a similarly situated person, this court had issued notice and directed that in the verification process, if is going on, the petitioner to give the petitioner an opportunity for his credentials to be verified. Stop. Let notice be issued returnable on 20 September. On 29, 2024, MS so-and-so accepts notice on behalf of 1, 2,
3,
1, 3, 4, 5, and 6.
Lordship.
Stop. Who is for 2? Who is for 2?
For 2, Lordship, standing counsel is there.
Earlier,
Standing
State level
counsel for
recruitment board.
state level recruitment board.
Lordship.
You're there?
Yes.
And
Lordship, B. Chaudhary.
B. Chaudhary for standing counsel, so and so, respondent number 2.
Yes.
Extra copies. Accordingly, it is provided that if the verification exercise is going on, the petitioner shall be given an opportunity for his credentials to be verified. List this case on 29/2024 along with WPC 4382 of 2024. Accordingly, in the interim.
if possible, my lord, maybe after verification.
No, let it come along with this case.
Lordship, the name of the SC SLRC.
Let name of Mr. B. Chaudhary, learned standing counsel,
SLRC.
SLRC, be reflected by the registry in the cause
Well,
list.
this case is listed today itself.
Oh, today's 20.
That's why, my lord.
After 2 weeks.
Much.
Last Lordship.
Returnable after 2 weeks, huh?
May I please allow?
Suspension.
My lord, kindly have a look on the page 47 and Annex 14. Order passed by the Honorable Court.
Page.
47, my lord.
Yes. Yes.
Yes. May I read the order, my lord? From third paragraph, my lord. It is the projected case that a petitioner was discharging his duties as Secretary of the Bhuvan Hill and the Dartpur Cow Panchayat, White order dated Swencho, thereafter White in order dated 8/1/24. His duties were restricted to Bhuvan Hill Cow Panchayat.
That
But-
is all right.
Yes,
In your
madam.
case, there is no periodic review.
No, my lord. Finally, my lord, page 48, there is a direction of this court. Within 15 days, there is a direction for reinstatement, my lord. Then, my lord, I submitted this order to Procedural, my lord. They have received at page 49, Annex 15, my lord. Now, for urgent, seeking urgent
This
justice
is,
petition before this court.
this decision.
Ajay Chaudhary.
No. The order at 45 is the same petitioner.
Yes, my lord.
So this is the second time you are coming.
Yes, my lord.
Why this order is not complied?
Lord, my lord, it is almost 50 days past, my lord.
Huh?
Almost 50 days, 56 days past, my lord.
Then
But,
why haven't you filed contempt?
my lord, for seeking urgent justice, my lord, we have filed instant petition. Then let them give explanation why they are delaying to reinstate of my petition order of this honorable court.
All right. Let me please point out the operating part of the order.
Yes,
Is
my lord.
it that last line? In
My
view
lord,
of
operative person also will find, my lord.
This court is
page
left
47, last bottom,
with
bottom
no
line.
other option but to direct reinstatement on the ground that an employee cannot be put under prolonged suspension.
Yes,
Yes, he's been reinstated or not?
No, also their instruction is not with me now.
No, but you see, on the next date, if the instructions are not there, I will direct personal appearance.
my lord.
This cannot go on. There is a positive order of this court for reinstating the petitioner.
Yes, I understand.
Why should the petitioner file another writ petition for executing this order? These kind of practices cannot go on.
Yes,
The orders of this court has to be followed.
Yes, I understand.
So please, I'm posting this on Monday. You
Yes.
get the instruction. Otherwise, you tell your officer to be prepared. It appears, one second. Heard Mr. P.K. Deka,
Yes, my lord.
Learned Counsel for the petitioner stop. Also heard Mr.
Cake war.
K. Kwar, right?
Yes,
K. Kwar, you're appearing as standing counsel.
Yes.
Learned Standing Counsel, PNRD, and MS.
8
A. Talukdar, Learned Government Advocate for the state of Assam. Stop. This petition has been filed by under Article 226 of the Constitution of India, primarily for executing the order of this court dated 26/7/2024, passed in WPC 1668 of 2024, whereby this court was pleased to direct the respondent authorities to reinstate him on the ground that an employee cannot be put under prolonged suspension without initiation of a departmental proceeding and without having periodic review to come to a satisfaction that such suspension is required to be extended. It is unfortunate that the order of this court dated 26/7/2024 is still not complied, faced with which this second writ petition has been filed for executing the said order. Be it be stated that a writ court is not an executing court, and the order passed by this court has to be complied unless and until the same is stayed or set aside by the appellate court. Stop. Be that as it may, before taking drawing an adverse order against the erring officer, this court directs Mr. So-and-so, Standing Counsel PNRD, to place the instructions as why the order of this court has not been complied till date on the next date of listing. Stop. List on Monday.
So Lordship, on 25th, Wednesday.
On Wednesday, so and so. It is needless to clarify that if the instructions are not forthcoming, orders including personal appearance of the officer concerned through virtual mode shall be ordered on the next date of listing.
Obliged, my lord.
Obliged.
6.
May it please the Lordship.
Yes, Mr. Roy.
The petitioner's father was working in the Panchayat and Rural Development as a night chowkidar. Thereafter, on his expiry,
What is the Mr. Chaudhary, Roy Chaudhary, what is you are seeking in this petition?
seeking, my lord, that under Panchayat Act, there is a provision under section 140, the persons through which the procedure which the appointment can be made under grade 3 and grade 4. Your Lordship may travel in page 35, where your Lordship will find that they are taking resolution in a meeting and giving appointments to respondent number 8. Page 35, third paragraph. This is not the procedure laid down under 140 of the Assam Panchayat Act, Staff Selection Board.
You are challenging this order.
I'm not challenging the order. My only prayer is that if there is any appointment, that should not go through this.
Then I'll issue notice at this stage.
Well,
Let
only
him
that-
take instructions.
Your Lordship, in this document relied upon my learned friend, Your Lordship, in the second paragraph, it is very specific, Your Lordship. No one has been engaged.
But third paragraph, you'll
Second paragraph.
I am asking
However,
about third paragraph.
outgoing.
Yes.
That paragraph.
Yes.
However, the outgoing,
Second paragraph, Your Lordship,
Huh?
it is to be mentioned here.
that as per office record.
It is to be
Yes, no
mentioned.
one has been engaged.
But on the third paragraph, your Lordship will find.
All right, let you obtain an
My only
instruction.
thing, my lord, nobody should be
Mr. Roy
appointed.
Chaudhary, let the instructions first come.
Only the respondent number 8, because third paragraph says somebody is appointed. It has been kept in abeyance.
Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. K. Kaur, learned standing counsel, PNRD. Anybody else? And Mr. C.K.S. Borwa for respondent 3. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned resolution of the meeting held on 30/11/2023 in the office of the outgoing president of South Hailakandi Anchalik Panchayat regarding engagement of the respondent number 8 as night guard in the office of the South Hailakandi Development Block. Stop. Let notice be issued, returnable 4 weeks. Mr. Kaur accepts notice on behalf of respondent numbers
1, 2, 4, 5, and 6, Your Lordship.
1, 2, 4,
5, and
5,
6.
6. And for 3, Mr. C.K.S. Borwa for 3 and 7 registered post.
Yes, Your Lordship.
7 and 8 registered post AD. Extra copies within 3 days, steps also within 3 days. Just format it.
Any appointment will be subject to the outcome of the writ petition.
list after the returnable date on a date to be fixed by the registry. It is needless to clarify that in any appointment made to the subject post, the same shall be subject to the outcome of this petition.
Obliged.
Gao Pradhan.
My lord,
Yes.
very unfortunate my lord, situation has arisen due to the arrangement in the government, my lord.
Due to
Due to the arrangement of some of
Harassment.
the arrangement and abolition of some of the department, my lord, the appellate authority is now, my lord, has been changed from one to another. We have preferred an appeal pursuant to the earlier, my lord, this honorable court's order, my lord. But that appeal, my lord, has not yet been, my lord, taken
Disposed
into
of.
account, disposed of, my lord. That is very humble and limited prayer before my
you
lord.
want the direction that the appeal be disposed of.
My lord, my appeal may be disposed of, my lord.
Any objection? You are appearing for the all the
Yeah.
respondents.
Yes, lordship. I am appealing for one.
Where is your appeal?
My lord, the appeal at page 59, annexure 9, we have not, my lord, it's a bulky one, my lord. That's why just
No, but what is the number of this appeal?
it has not even been not numbered also, my lord.
But this appeal is.
Appeal is
so
acknowledged,
I will
Lord.
dispose of the saying that
My lord.
if the appeal is pending before the
Yes.
divisional commissioner so
No, my
and
lord.
so,
No, no,
the
not-
same to be disposed of within 3 months.
Yes, sir.
My lord, divisional commissioner has been abolished, my lord. Now, my lord, may kindly turn.
Before, but where is this appeal pending, Mr. Counsel?
My lord, that has been that can be apprised by my learned friend, my lord. Because when we went to the divisional,
Yes, where is it pending?
After abolition of this divisional commissioner post, all the appeal has been transferred to the DLR, the Director of Land Records.
Director
Of Land Records.
of Land. All right.
Page 61.
This is item 7, huh? For disposal. Heard Mr. A.R. Bhuya, learned counsel for the petitioner. Stop. Also heard Mr.
As Doctor.
S. Dr. Learned. You're
Standing
appearing as government advocate. No.
Standing Council.
Learned
Revenue.
standing counsel, revenue.
Lordship.
Revenue. MS A. Talukdar, government advocate. Anybody else? GAD? Standing counsel is there? Okay. By way of this writ petition under Article 226 of the Constitution of India, comma, the petitioner is assailing the appointment of respondent number 6
My lord.
to the post of Gao Pradhan
Gaon Pradhan, my lord.
for
Lord,
villages Dhupguri,
Miyabari.
Bhuyabari Pump and Bhuyabari Pathar Hisam. Stop. Before entering into the merit of the matter, it appears. Don't say that. It is submitted at the bar that the petitioner has filed an appeal before the Divisional Commissioner Central Assam Division, which is now being forwarded to the office of the Director of Land Records, and the same is pending.
My lord.
Stop. In view of the aforesaid endorsement made by the learned counsel for the parties, comma, this court deems appropriate to dispose of this writ petition at the motion stage itself by directing the appellate authorities within bracket divisional
Director of
Director of Land
Land Records
Land-
and Service.
Records and Survey to dispose of the said appeal filed by the petitioner within a period of
2 months.
90 days.
3
months.
3 months from the date of receipt of the certified copy of the court's order disposed of. Appeal if any. If any. Huh?
It has been acknowledged by the division.
That's all right. If the appeal is pending, they will dispose of.
Obliged.
You see, I have disposed it now before the entrance of the private
My
respondent.
lord, my lord. He can also be heard, my lord, by the appellate. My lord. Obliged.
All right, I'll add that.
Yes, yes, my lord.
It is needless to be clarified that in the appeal, before a decision is taken by the appellate authority, the petitioner, including the private respondents and other stakeholders, be heard.
My lord. Obliged.
May it please your lordship.
Yes, Mr. Das?
My lord, the petitioner, my lord, is working as a peon, my lord, in the office of sericulture, my lord. Hatsing, my lord. He already had a graduate degree and also diploma in computer, my lord. He intimated the same to the department, my lord, at page number 29 on 28 to 2023, my lord. But when the final gradation list was prepared, my lord,
Your name is not included in the
no,
petition
it was
list.
included. BA degree was included, but computer diploma was not included, my lord. My lord will find that, my lord, at
What is
page,
your
page number
prayer today?
38. 38, my lord.
What
Serial-
is the prayer?
Prayer, my lord, to reflect the computer diploma in the final gradation list, my lord, so that he does not get deprived
My lord,
of the
this is
benefit.
not so easy, my lord. I tell my lord
Hmm?
what happens, my lord.
Yes, Mr.
When
Dhar?
initially he joined, my lord, he did not declare regarding his, my lord, degree.
File your return.
Yes, my lord. We'll just, my lord, issue notice, my lord.
At this stage, nothing can be
If
more
your lordship
given.
will kindly see the last page, my lord, they may
I
have-
cannot grant the final order today.
Yes. Yes.
My lord.
Heard Mr. S. Das, learned counsel for the petitioner. Stop. Also heard Mr. R. Dhar, learned standing counsel,
Handloom, textile, and
handloom and textile. Stop. By way of this application under Article 2 to 6 of the Constitution of India, the petitioner is seeking direction to the respondent authorities, more particularly to the respondent number 2, to modify the final gradation list dated 27/2024 so far as it relates to adding the computer diploma certificate qualification of the petitioner under the qualification column in serial number 88 of the list, I, the petitioner. Stop. Issue notice, returnable. I'll make it 2 weeks because otherwise the
Yes, my lord.
subject matter may become infractious, Mr. Dhar.
Yes.
So you act immediately before puja, huh?
If your lordship will see the last page, my
Issue
lord,
notice, returnable 10 days.
My lord, it will be in 10
You
days.
just have to get this information, why his name is, why this degree cannot be included, correct? It's
Yes,
a very
my lord.
short point.
Short point is that, my lord, while entering into the service balance in
You put that
2015,
in a way of an affidavit and it can be disposed
my-
of at
my-
the
my-
admission
my-
stage. You are accepting for all.
My-
Her notice, and since so and so accepts notice for all the respondent, no formal extra copies, you just put all that, huh? And considering the prayer involved in the writ petition, it is desirable that the return be filed by the next date of listing, and on that date an endeavor shall be made to dispose of this writ petition at the admission stage itself. Okay. List on, yes, give a date on such and such date
4th of October.
for admission.
4th of October.
410.
Not any protection, my lord.
No, I am. You see, the whole point of giving such a short time is to ensure that your case doesn't become infractions. No further
Hello,
protection. Yes.
Sir, before I starting, I must say, my lord.
Yes, Mr. Roy.
Yes, my lord. A coordinate bench, my lord. A coordinate bench, sir, dismissed a petition, my lord, relating to an advertisement of 2020, my lord, relating to, my lord, filling up the regular vacancy, my lord. And that judgment was passed, my lord, on the basis of the Repeal Act, 1995 Act, not the 2016 Act, my lord. But this petition, my lord, relates to an advertisement of 2018, my lord, for filling up backlog.
According to you, that decision is not applicable.
Not applicable, not similar matter to that.
Yes.
Yes, my lord.
You are not aware.
Not aware.
Ms. Sharma, are you aware?
He said that it's not similar.
It's not said.
Similar. He said.
Anyway, we'll issue notice
Yes,
and
yes, Lord.
you look into it.
Only difficulty is, my lord, as per section 34, section 2, my lord, the government is allowed to fill up other than the disabled persons, my lord. And
Other than the disabled.
other disabled person, my lord. This is the post of the advertised for the backlog vacancy. There's this post reserved for the disabled person.
Mr.
not
Roy, since there is already some decision of this court where that petition was dismissed and the respondent lawyers are not aware, Either I can
My
have
lord,
this
my lord,
matter on Monday,
my lord, I have already filed.
then let me have this matter listed on Monday. You give a copy of the.
Yes, my lord.
Yes.
I have.
Yes,
I
Ms.
have.
Sharma, you have a look at it.
Yes.
Covered, not covered.
My lord, I have filed review petition. Notice has been issued in that.
Heard Mr. S.K. Roy, learned counsel to the petitioner. Also heard M.S. Yes, your name?
MM Kotoki,
M.M. Kotoki, learned.
Standing Council, Animal Husbandry and Veterinary
Standing
Department.
Council, AH&V Department. S. Sharma, Standing Council,
Health Department.
Health Department. Mr. Alok De for respondent number 5. And anybody else? J. Gogoi for respondent number 2. MS 8 Alukdar. Respondent number 2. Respondent number 1. Mr. Roy submits that there in a similar situation. I'm not saying. Give me that decision. Mr. Roy fairly submits that this court that the coordinate bench of this court in the case of WPC 3015 of 2024, in the case of Dinamani Saikya versus State of Assam in WPC 3015 of 2024.
Similar.
Similar.
And then my lord, para 21.
Has held a prayer of the similar nature to be not maintainable. Stop. However, he distinguishes these facts of the present case and submits that the said decision is not applicable in the facts of the present case. Stop. Let a copy of the said decision be served upon the respondents to apprise the court as whether the case is whether the decision of this court in WPC 3015 of 2024 covers the present case or not. We check that list again on Monday or Wednesday.
Wednesday.
Please give your appearances. It gets confusing otherwise.
My lord, the
Item 38 to Lordship 41 are similar matters.
Item
38 to
38 to
Lordship. 38.
they are in the admission column.
Yes, Lordship. 38 to 45, Lordship. Similar,
38
Lordship.
to 45.
Yes, Lordship.
In item 38 to 45, you see in view of this.
my lord, in 44, my lord, there is an order, my lord. Today, notice has been issued on the interim prayer also, my lord. In 44, my lord.
So when do you want this? I'm posting it
On Wednesday.
Wednesday only.
Lordship, 38
item
to 41,
38 to 40.
1, and then 44, 45.
Please give the numbers.
Yes, Lord.
Numbers kita loilo, but post on Wednesday.
Highly obliged, Lordship.
Number to loilo ba, ठीक? भूल गया मैं।
Made pleasure, Lordship. My lord, we are assailing this order of termination at page 90.
Page 90.
Yes. I am a provisional, my lord. I was appointed as an assistant professor in neonatology in July 23.
You are holding the post of
Assistant professor,
in
neonatology,
Guwahati.
All India Institute of Medical Sciences, Guwahati.
Your services was terminated.
Yes, kindly see, my lord. In pursuance of the terms and conditions mentioned in the appointment referred to above, I hereby give notice to Dr. S. Rohit, presently serving on probation period, that his services shall stand terminated with effect from the date of expiry of period of 1 month from the date on which this notice is served on, as the case may be tendered to him. Actually, my lord, lordship knows under Rule 5(1) of the temporary service rule, 1 month notice or pay in lieu of 1 month can be given. But my lord, this provision is not applicable. If your lordship would kindly come to page 91. Rule 5.1 is actually not applicable to probationer. Yes.
Here
A
he was a
question-
probationer.
I'm a probationer. A question is arisen whether this rule should be invoked also in case of persons
So
appointed
you're
on.
challenging this termination order only for on the ground that this rule is not applicable.
Number one, and number two, the authority decision has been taken by an authority who is not even competent. And thirdly, my lord, it's absolute malafide. I'm a probation, my lord. If my performance is not satisfactory, then under the relevant instructions issued by the government of India, I must be put to notice. All this, there are on 3-4 grounds I'm
There
assailing.
is no difficulty for issuing notice.
Well, I'll be praying for a stay because prima facie I'll satisfy my lord, this order cannot stand. Even if the other side appears, my lord, they cannot improve this case. Just kindly give me 5 minutes time, my lord. I'll have to place 2 points. Now, this is regarding Rule 5.1 is not applicable to probationer.
All right.
Now, kindly come to my appointment order at page number 35. Please come to page 36.
Yes.
3. Your appointment may be terminated at any time with 3 months' notice by either
Appointing
side.
authority.
So, my lord, there has to be a 3 months' notice. It is not there. Number one. My lord will kindly come to
1 second. By 3 months notice and
or
by either
pay
the
in lieu thereof.
either by the appointing authority
Yes.
without assigning any new whatsoever.
Yes. So that has not happened
What
here.
is either?
Either vide appointing authority.
Yeah, I think that
Either
either
original is at page 41.
maybe a misnomer. Anyway, 3
Yes.
months and appointing authority.
Yes.
Yes.
Now, my lord will. Now, there is another aspect, my lord. Petitioner's wife, she is also a faculty member in the IMS. My lord, she has been subjected to sexual harassment in the office. Now, my lord, there was an ICC, and ICC has indicted respondent number 6. Now, what the authority has done, my lord, without any power, authority has said they will not accept ICC's recommendation. Then, my lord, if they do not accept the recommendation, my wife's view must be taken. Because I am hesitating all these issues, my lord, the respondent number 5, I has become his eyesore. Now, please come to the rule position, my lord. Now, please come to this ICC report at page number 54,
A
my lord.
departmental inquiry was held.
Yes, ICC has. Please come to page 54, my lord. Respondent number 5 and 6. I have made.
The limited jurisdiction that this court has. It will be difficult to stay. I'm issuing notice, and I'll keep the issue of interim open, and let Mr. Gogoi, can a date be fixed before the vacation? You have it because I am keeping the interim open.
No, my lord, the order has not taken effect. It will take
Till
effect
then,
at
don't
the end
take
of 1
effect.
month. Yes, till then.
Till then,
Till they file the
already
affidavit.
notice is
no,
there.
I'm
No,
issuing
the
I'm
notice is-
issuing notice on the interim as well. And till the next date, let status quo be.
Yes.
That part also I will satisfy. That
You
part I will
you
satisfy.
uh,
Otherwise,
you
Lordship,
appear on
other-
that you place everything on that date.
Lordship,
You see, if they have
11/9 only
if he has already handed over, he's handed over.
Lordship,
And I am not giving any
we have
interim
given,
today.
Lordship, already we have given 1 month notice, Lordship. There was an addendum also. I will place it. Let my senior will finish his argument, then I will place my
But do you have everything?
Lordship.
The
Lordship.
records are here.
Lordship, I have the addendum here, Lordship, where we
The
have.
addendum is not okay. You file your affidavit.
Lordship, I will file, but status quo as on today, yes, because 1 month notice is given, Lordship. 1 month notice is.
When is that 1 month notice
That
expired?
10-8, my lord.
10?
10-8. Sorry, 10-10. By 10-10, this order will take effect.
All right, then I will
10,
fix
10,
it. Then
10,
I'm
nothing
fixing
will
a
happen,
date
Lordship.
before 10-10.
10,
Yes.
nothing will happen.
I am
Lordship.
fixing a date before 10-10, Mr. Gogoi.
10, nothing will
Third,
happen.
Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. SP Sharma. Also heard Mr. K. Gogoi, learned, you're appearing as
Lordship, I am a CGC, Lordship.
learned CGC. By this petition under Article 226 of the Constitution of India, the petitioner is challenging the termination order dated 11/9/2024 passed by the respondent number 5. Issue notice returnable on before 10/10 the date due.
There are holidays during that.
On 3rd October,
Lordship.
3rd October.
on 3/10/2024.
Yes, sir.
Stop. You're accepting notice on for
1 to 4, Lordship. 1 to 4.
Since Mr. K. Gogoi accepts
Director is
notice on
also there,
behalf-
but by name, Lordship, I cannot. By name,
1 to 4.
1 to 4 I can, Lordship, but
That's what.
4 and 5 is the same
Yes,
and
I
non
have taken note, Mr. Gogoi. Accepts notice on behalf of respondent numbers 1 to 4. Extra copies within the course of the day. Within the course of the day, huh?
Yes,
Extra
yes.
copy. Registered post AD in respect of 5 and 6.
Plus, Lordship will permit us dusty also.
Considering the urgency involved in the matter, the petitioners are permitted to take dusty service as well against the respondent number 5 and 6. List accordingly. It is needless to clarify that considering that the termination that the impugned termination order dated 11/9/2024 will come into effect on 10/10/2024, the respondent shall file their return on the next date of listing, failing which the interim order sought, failing which the interim prayer sought shall be considered on the in accordance with law.
Lordship is fixing on 3rd, Miller.
Status quo to be maintained.
Yes.
Or status quo as on today be maintained
Lordship,
till
on
then.
11 nothing will happen, Lordship. Our order
Your,
is
it
for
will
11.
come
Lordship.
only on 10/10.
Lordship.
Yes.
Oblige, Lordship.
Status quo to be
Yes, Mr. Chaudhary.
Yes, my lord. My lord, this matter I
Gradation
come-
list cancelled.
Yes, my lord, because my lord, before my lord downgrading my position in the gradation list, I have specifically taken part my representation that I was not served in notice, my lord. It was not circulated to me, my lord. And that has been mentioned in earlier order or interim order also passed. Before also go to the speaking order, my lord, nothing is there, my lord, in respect why notice has been served to the petitioner when downgrading his position in the gradation list. Lordship first going to the my lord.
You have
order-
been downgraded.
Yes, my lord. Then respondent number 5, my lord. That is the issue, my lord. Whole issue, my lord.
And no notice was given to
No
you.
notice was given to me.
How
That
this
is
was done?
We have to take instruction. We have to take instruction, Lordship.
till then, my lord.
What till then?
A short-
Necessary, my lord. They are going
A
to
short
promote
Till
the
notice.
then
post.
what? What do you want till then?
That promotion to the post of superintendent shall not be filled up, my lord.
Who is the
By the
respondent?
gradation. Yes, my lord. Respondent. They are going.
Actually,
my lord.
short date may be given.
Lordship,
I will
kindly
take
go to the
instruction.
chairman.
You had earlier approached this court.
Earlier approach
Where
this.
is that order?
Yes, my lord. Lordship, kindly come to the my lord. Page 81, my lord. 83 is the from operative part, my lord.
80.
3. If you lordship go to the my lord, paragraph 2 also, my lord. Everything has been mentioned.
82.
Yes, my lord. That the petitioner initially LDA in the director of the petitioner joined in the 1/11/1990. Actually, that was wrong, my lord. It was corrected by subsequent IA, my lord. 1990, my lord. The respondent of who joined in the 1/12/1990 under the same director as amalgamated the project education LDA. Typist directorate was received under 12/6/1990, wherein the name of the appear serial number 20 as typist and respondent appear to 29. The gradation list typist LDA relation published under so and so order 24. Typist and cell number 23 LDA. Then you will say by another order 27, the provision of the gradation list LDA typist.
Go slow, Mr. Chaudhary.
Sorry, man. The provisional gradation list typist of the director information publication as published wherein the name of the serial number 13 and the respondent number 14. The petition is agreed by the order dated 1/11/2008 by the gradation list typist. Director publication published wherein the respondent number has been placed, serial number 9, and petitioner has been typist. In the case of the petitioner, the order dated 1/2008 which has been published in the gradation director relation done behind the back of the petitioner without giving any notice. That is important, man. Being aggrieved, the petitioner made a representation before the director of information and
All right,
public
this
relations.
is okay. Now, accordingly, after hearing, this will be
According
disposed
after
of
hearing the representation dispose of states
Action.
directing director information on to dispose of representation.
So this is done or not done?
That was done, my lord. I have stated in my representation that no notice has been served. It is not within my knowledge, my lord. And it is violation of Article 14.
And now that disposal.
Yes, my lord.
Speaking order you have challenged in this.
Yes,
petition.
my lord. Yes, my
Where
lord.
is that order?
That is, my lord, page 88, my lord.
Page 88.
Yes, my lord. Yes. Where is the Honorable Guwahati High Court in the order? In the case, Pramod Chandra Saika, senior assistant in the order of
Page,
the
page.
page, my lord, 88.
Ajay, Mr. Chaudhary,
In our petition, there is one page. It is not that.
Oh. That is not available, my lord. It can be
not available. Then I'm having it on Monday. You
71
ask your
of the-
junior to give her a complete petition. It appears that the
I
complete,
understand.
set of the writ petition is not
No,
been
no, what
furnished
is the
to
case
the
number?
government
There are-
advocate. Let the same be served. List again on Monday. Monday. You give him today only, Mr. Chaudhary.
This is the
All right, next matter. Yes, please sort it out. Yes, next matter.
May I please?
Denovo.
Yes. And you also kindly see the impugn order. Kindly see the impugn order.
Page
Page 21.
20.
21.
21.
21. Annexure B. The last paragraph. Whereas the disciplinary authority perused the finding and found not to be satisfactory as Sri Ajay Kumar Hendik under suspension inspector of police were apprehended by a trap team of Directorate of Vigilance and Anti-Corruption Assam for demanding bribe and accepting it through middlemen.
Accepting it through
Through middlemen. Through Mukhtar Hussain. Hence the finding dated 22nd 8 2024 is not accepted.
So you are challenging this order?
Yes. There is no material irregularity.
They found it is not satisfactory,
Yes.
and therefore the authorities
Yes, Lordship.
wants to.
And
Well,
the
the
charges
Denovo,
are
what is
grave,
wrong?
Lordship.
No, Miller, there is no provision. There is no specific power. In the Assam.
The authorities wants to do it. How can
You
you?
also can see the reason ground, Miller. Only they can go for Denovo inquiry, Miller, when, Miller, there is material irregular.
No, they are saying that there is some unsatisfactory materials, and they want to satisfy themselves.
Your lordship may read again, Miller, why they are
Yes.
not satisfied. The main reason for not satisfaction, Miller, because according to the disciplinary authority, he was apprehended by trap team. That is the only ground.
You are reading from whereas the disciplinary authority perused the finding
Finding.
and found not to be satisfactory,
Yes, ma'am.
as so and so were apprehended by a trap team
Trap team.
of the Directorate of Vigilance and Anti-Corruption Assam for demanding bribe and accepting it through middlemen. So according to them, there are,
Those things has been taken
Mr.
care of.
Counsel, I can issue notice, nothing more. Otherwise, this court doesn't.
Well, there are-
In fact, I am not sure if the relief is maintainable, because on the face of it, you cannot stop them from holding a de novo when there are materials which they want to further find out.
Yes. My lord, may I please to of the judgment of this court?
No judgment required at this stage. This court is not satisfied
My lord, within
on the
35
facts
days,
of the case.
my lord, there is
Yes.
a direction to complete the
You are Mr. Rafiq. Heard Mr. I. Rafiq, learned counsel for the petitioner. Stop. Also heard MS M. Bhattacharjee, learned additional senior government advocate for the state respondent. For all respondents,
Yes, Lord.
By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking is assailing the order dated 2/6/9/2024 issued by the respondent number 4, whereby it was directed, whereby it was directed for whereby a de novo inquiry has been directed. Whereby a de novo inquiry has been directed. Stop. Issue notice returnable 3 weeks. MS so and so accepts notice on behalf of all the respondents, extra copies within the course of the day.
One thing, within 30, there is a direction to complete the proceeding within 35 days. So the short date may be given.
Huh?
Within 35, there is a
All
direction.
right, all right. Yes, when can you have it?
Lordship, immediately after the reopening, Lordship.
So, returnable on weeks, Nokoba, date to deduction after opening
23rd.
on 23rd.
It will be over in the meantime. And it's subject
30
to
days
the
will be over.
35 days, my lord. They have
All right, then I will say any order passed shall be subject to the
Yes,
outcome
yes.
of this petition.
obliged.
Deeply obliged, Your Lordship.
Yes, Ms. Chaudhary.
Amendment.
Pensionary benefits.
My lord.
Pensionary benefit.
Yes, my lord. But my lord, I have filed one modification petition, my lord,
I trust.
for modification of the prayer portion of the petition, my lord. Only few lines, my lord. That was by
Any
mistake,
objection?
my lord, it was dropped.
But we have not received a copy of the IA.
You have
have
not
given.
served a copy of the IA.
Yes, we have already given, my
He
lord.
says he has not received.
Well, I have
Sir,
the petition, but not the IA.
I have given the notice is there, my lord. We have already given, my lord. Otherwise, my lord, would not have been accepted.
what is it? Tonight. Yes, it will notice if it's there. One. Anyway, call
Only
the
the prayer
next.
portion, my lord, at page.
Yes, please see. I don't think there is any notice. But Ms. Chaudhary, please have a look. The file doesn't show any notice.
My lord,
Anyway, you give him a copy.
doesn't show it.
Give him a copy right now. Have a look at it. If it can be disposed of, we will take it up after some time. And if you want time, we'll give you. Please give him a copy and wait. Call the next matter in the
The
meeting.
read petition, my lord. It is there in the read petition. The
All
notice
right,
is
let
there.
him have a look, Ms. Chaudhary, because he says he has not got it.
It's okay.
Let him have a look.
My lord, can it be on Monday, my lord?
Today itself.
Today itself.
Let him have a look. I'm calling it after some time.
Okay. Obliged.
After the motions, Matidiva, I'll over there. Yes.
Wait, Your Lordship.
Yes, Mr. Decca.
Lordship,
Promotion.
Promotion, Lordship.
Superintendent.
Superintendent.
Notice.
Notice, and in the meantime, this may not be a bar for,
This cannot be a bar for?
because notice, the only
No, this cannot be a bar for?
this pendency of the repetition may not be a bar for him to consider.
All right. Heard Mr. P. Decca, learned counsel for the petitioner. Stop. Also heard MSM Bhattacharjee, learned additional senior government advocate Assam, appearing for the state respondent. Stop. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking direction to the seeking direction in the to the effect of considering and grant of promotion to the petitioner to the vacant post of superintendent within bracket training wing in the Directorate Office of the Employment and Craftsmen Training, Assam. Stop. Issue notice, returnable 4 weeks. All respondents. MS Bhattacharjee accepts notice for all the respondents. Extra copies within the course of the within a period of 3 days from today. Stop. List after 4 weeks on a date to be fixed by the registry. It is needless to be clarified that pendency of the writ petition shall not be a bar for the respondents to consider the petitioner for promotion to the subject post.
Highly observed.
Transfer.
Yes. Your Honor,
Oh, this is the 2 months.
yes.
Lordship,
Why was it transferred within 2 months?
Lordship, we have yet to receive the instruction. I was just over to telephoning instruction. I was taking some instruction, Lordship. Can it be fixed on Monday, Lordship?
Monday. MS
8 Alukdar.
as prayed for by MS A. Talukdar, learned government advocate, to the effect that she has verbally received partial instructions and that the complete instruction shall be received by her within the end of the week, and the same can be placed before this court by Monday. Prayer allowed. List on Monday.
Till that status quo, because till
Yes,
today,
next.
Obliged, Lordship.
Your Lordship, till today it was status quo was maintained, Your Lordship, by your last order.
It was there.
Yes, yeah. 18 on last day before yesterday.
Status quo till then.
Obliged.
These petitioners are workers. Petitioners are workers of NIT Silchar. Since 1989, they have been engaged by a process. That is by a selection process, but not in advertisement. And their assurance is given that they should be regularized because they are holding the sanction post. And
What is your prayer here for setting aside the advertisement?
No, advertisement was previous on earlier round of litigation. The 7/7/2000 the advertisement was challenged and it was disposed of 23/7.
No, but at page 44, is this not the prayer in this repetition?
Yes.
The first prayer is setting aside advertisement 7/7/2023.
Because that was under challenge still. Because pursuant to advertisement, they want to fill up this post by fresh candidate without regularizing the petitioners association because they are 30 years.
All right, notice nothing more at this stage.
My lord, they may fill up this post. I have given the list. So status quo may be maintained by
What
the,
status quo?
My lord,
You have not come by way of an advertisement. Your appointment is not by way of an
my lord,
advertisement.
there is a order of this honorable High Court, my lord.
The apex court decision in 2011. If your entry is not by a proper mode, no relief whatsoever can be granted. That decision is there of the apex court. You have not been appointed through a valid process.
No, my lord. Because at that time, sanction post was there. We are not illegal, backdoor appointee. We are through, it may be irregular.
By advertisement.
Yes. That
There was an advertisement. You have been appointed through an advertisement.
But they have adopted
No,
that.
answer the query of the court. Have you been appointment through?
Grateful that at that grateful not advertised there.
Correct.
Yes. But selection test is there, my lord. Kindly see calling letter annexer C. My lord, kindly see page 54. Calling letters are there. Petition number. And at that time, Umar Devi was not there, and they have not also done this. And
Rupak, etu dibo pariba ni 2011 volume 3 SSC 436. 2011 volume 3 SSC 436. There it has been held that if appointment is without advertisement, he is not entitled to any relief including salary. To that extent.
yes, ma'am. But my lord, our is the case, my lord. Says Umar Devi.
Who is appearing in the other side?
My lord, I have served the copy. This is the CGSC and my lord, there's NIT. Both of them copy has been
Where are
served.
they?
And there is a direction of this honorable court, my lord, to consider the regulations. As per Umar Devi's, my lord.
You get hold of the respondent lawyers, will recall the matter. Wait for some time.
Yes.
Just wait. Ask your junior to get hold of
Yes, my lord.
Time being corridor. Yes. 2015. This is compassionate.
Yes, Lordship.
When did you make your application? When?
The father of the petitioner died in the month of February of 2008.
Father, February 2008.
October of 2007, and he made the application on February of 2008.
Application
On February of 2008, 26/2/2008.
2008. Date of application?
My lord, the
26/2.
matter may have become infructuous.
22/6.
26/2/2008. Application was made.
Yes, yes, Mr. Dhar, what are you saying?
My lord, again half it was placed before the direction, and it was placed before the SLC, DLC, then SLC. 2018, 22/11/2018. It was again rejected, my lord.
Rejected.
Rejected by the SLC, my lord.
Yes, Ujjal.
My lord, I have just marked the highlighted with the instructions, my lord. Even now, if they want to, they have to challenge this order, my lord. This is SLC.
Have you seen this?
No.
You'll have a look, because this court doesn't feel that any you have a case, because you see the entire object of compassionate appointment by now has been lost and diluted, and DLC has already rejected your case. You have a look.
Okay, Lordship, can it be taken at 2 p.m.?
No, you have a look next week. Give a copy. Mr. D. Dhar, learned, you're appearing as Learned Standing Counsel, PWD.
My lord, additional senior. I will appear for all, my lord.
Additional senior government advocate for the state submits the correspondence received from the office of the Undersecretary to the Government of Assam, establish-B branch, PWRD, by letter dated 17/9/2024, whereby it is informed that the case of the petitioner for appointment on compassionate ground was rejected by the SLC in its meeting held on 13/2/2014. And though, as per the order of this court dated 19/11/2015, the case of the petitioner was reconsidered by the next SLC, the SLC in its meeting on 19/6/2018 again rejected the appointment application of appointment of the petitioner on compassionate ground, on the ground that, within quotes, already filled up with 5% quota dash a comma, more than 10 years have been elapsed since the death of his father, comma, overage and underqualified, within quotes. Prima facie, this court is of the opinion that the case of the petitioner being belated, the object of compassionate appointment, which is to mitigate the immediate hardship, has by now been lost and diluted. However, since the rejection orders, since the second rejection of the SLC has not been served on the served on MS Bora and MS so and so, Learned Counsel for the petitioner, the matter stands adjourned to, yes, next week a date.
30th Lordship.
to
30th.
30 to 39/2024, comma, to enable the said council to respond to the said developments. Stop. Let a copy of the correspondences, including the rejection of the SLC order, be served to the learned counsel so and so for the petitioner by Mr. R. Thorswell.
My lord, I have given, my
The
lord,
list according.
my lord, the registry may show the name of FCPWD. Last time there was a direction, my lord, it didn't come.
Let the name of SCPWD be reflected in the cause list. Shall I retain this? A
Yes,
copy of the FOA correspondence to Poitiba kept on record and marked as X.
my lord.
Quite whatever.
14, 15, and 16. Made this your lordship. For my learned friend submits your lordship. On the last occasion, I have made a submission that the
Up-to-date instructions.
lordship, the case of the petitioner has been placed before the LR for its legal views, your lordship. So that views is still awaited, your lordship.
All right. G. Borderloy.
The body, lordship.
Mr. Sri G. Borderloy, Learned Standing Council Corporation Department submits that he has received up-to-date instructions in the matter to the effect that the case of the petitioner
has been placed before the principal secretary, and it has been sent to the LR for its legal
and
views.
the same has been sent to the
LR for
LR
legal
for legal
views. Your
views. Stop. And he accordingly seeks some accommodation in the matter. Stop. Prayer is not opposed. List this matter after
On 3rd, my lord, 3rd October.
after vacation.
Vacation because he has already retired.
Well,
my
a
lord.
lot of matters now fixed
Immediately
before the
after
vacation.
vacation.
He has
Immediately.
retired.
Reopening date.
Lordship, lordship.
Yes, Mr. Day.
No, this was,
Maintenance. Some instructions were called for.
Yes, my lord. I'm not receiving writing, but
Mr. Mehdi.
my lord, instruction I'm not receiving writing, but I received the record, my lord. My lord, the record speaks, my lord, this maintenance given, my lord, to the respondent 4, my lord, the wife, my lord. It is as per, my lord, the there is office order, my lord, 1/4, my lord. 1/4 was given, my lord. Yes,
So the order of this court is very clear in a specific instruction in writing.
yes, my lord. I've
So
received-
you place it whatever you have
yes,
received.
yeah.
Let both parties be aware also what is happening.
Yes, my lord. This
Mr. S.K. Mehdi, Learned CGC, submits that that he has received the records relating to the query posed by this court by order dated 13/9/2024 and accordingly seek some accommodation to place the same by way of an affidavit.
Yes, ma'am.
Stop. Prayer is allowed. List yes on
after 2 weeks, my lord.
immediately after the vacations, my lord.
after vacation date be there.
28, 20, after 20. 28,
20th October. 20th October.
second November. 2nd November.
2nd November.
4th November.
Please, your lordship.
Affidavit has been filed, I think.
Affidavit filed, but my lord, record of the proceeding has not been yet filed.
Do you want to file a rejoinder?
My lord, kindly see 17-2, my lord. For
Who is
17
appearing for the respondent?
Scenery is on lakes at different court. Kindly the matter may pass over for some time.
No, the petitioner is saying the records would be necessary.
Should the
You
file-
want the records?
Yes, my lord, kindly see 17-2.
So I will say that on the next date you produce the records. You are not filing rejoinder.
My lord, rejoinder, my lord, they file affidavit, my lord. My lord, they submitted all the records I have filed, my lord, already in my writ petition, my lord. And they have not yet, my lord, denied
In view
the,
of the submission made by Mr. A.J. Atya,
my lord.
learned counsel for the petitioner, let the records be made available on the next date of listing by the respondents. List on, yes, after vacation next week or November or December.
30th of October.
You followed what has happened?
Yes.
You communicate to your senior. Yes.
Like here the petitionary before the lawsuit is
Record was called for by way of an affidavit. Yes, respondents. Mr. Ghosh had appeared on the last occasion.
PNRD.
Yes. You're appearing? What happened to the counter affidavit?
Well, there's a
Hmm?
well, he has filed his representation. His representation is dated so that well, directions may be otherwise given, but he's still continuing in service.
Well, I am continuing service.
This is for area pay and allowances.
Yes, yes.
Yes. What records and all you need? Where is your counter? Why so much time being taken?
Well, he's seeking necessary orders of voluntary retirement from service.
Is it?
His prayer is at
Well,
page 18, Malad.
Yes, page 18.
No, I think is this not 6400?
Yes, Malad.
Yes, sir.
6400.
A writ of mandamus shall not be issued directing the respondents to release the area pay and allowances of the petitioner with effect from the month of July 18 and directing the respondents to pass necessary order of voluntary retirement. Okay. Yes, what about your return?
Malad, as per the judgment, from the date of filing of the writ petition, arrears can be only paid 3 years prior to the date of the filing of the writ petition. So if his writ petition was filed in the year 2023, Malad, month being October, so 3 years prior to that, 23, 22, 21 and 20 will be only eligible for arrears, if at all he is eligible, only till 2020, not beyond that. The judgment is very clear, my lord.
Mr. Counsel, have you seen the last order?
Last order.
It is very unfortunate when government councils do not see the last order and unnecessarily waste the judicial time of this court. There is a specific direction of this court on 5/9/2024. You are not even aware. Last occasion it was Mr. Ghosh who had appeared for the respondents. Today he is not here. Someone else is here. So if you were not there on the last occasion, at best you can check the order. Nowadays you get them online.
I'm sorry.
How much time does it take for you to figure out what was the last order? Because then you know what is happening. There should be some continuity maintained. Yes or no?
Absolutely. My mistake.
Now you want me to read this order to you? Learned counsel for the respondent submit that the reason for non-payment of the salary of the petitioner is due to the fact that there was an order dated 26/12/19 promoting the petitioner to the post of assistant engineer so-and-so and that the petitioner has failed to join the said post. Learned counsel for the petitioner submits that the said order has not been duly furnished to the petitioner. In view of the above, the respondent shall bring on record the order dated 26/11/19 by way of an affidavit while filing counter affidavit. That is why this court is repeatedly asking, have you filed the counter affidavit?
You haven't.
So you comply with
I
this. There is
comply
a
with
judicial order.
Now, let me kindly
How
grant
much
the
time?
2 weeks time.
Your name?
P. Handick, my lord. Appearing on
Mr.
behalf-
P. Hendick, Learned Counsel,
Appearing on behalf of K. Kumar.
appearing on behalf of
K. Kumar, my lord. Senior
K.
standing.
Kumar, Learned Senior
Standing
Counsel,
PNRD.
PNRD, seeks further 2 weeks' time to comply with the direction passed by this court earlier on 5/9/2024. The prayer is not opposed. List this matter
My lord,
after 2 weeks on a date to be fixed by the registry.
My humble prayer is that, my lord, may be fixed prior to Puja vacation because it is a non-payment of salary.
All right. 2 weeks, Nidibam,
10 days.
before vacation.
Nice.
Before vacation.
Deeply obliged.
Yes, Mr. P. Hendig had obtained time for filing counter. Filed. Nothing is filed after 3/9/24.
Well, we still need some time.
Huh?
The instructions are still awaiting.
Still awaiting. Last chance. As prayed for by Mr.
P. Handy.
P. Handy, Learned Counsel for the respondent numbers 1 and 5. A last chance is given to file the return in the matter. List after 2 weeks on a date to be fixed by the registry.
Hello.
You will file something. You are filing something or you will.
Madam, I am for respondent number 7.
Respondents are all represented by their respective counsels.
In this case, last occasion directed to take inside or file affidavit. Ma'am, kindly give 1 week. I have already communicated the Ministry of MHA.
All right, Ms. Gayan. As prayed for by MSA Gayan Learned Counsel for the respondent number, Learned CGC.
CGC.
Learned CGC, which is not opposed by Mr. B. Chakraborty, Learned Counsel for the petitioner, comma, list this matter after
1 week, my lord.
after 1 week on a date to be fixed by the registry to enable the Learned CGC to file the return in the matter
1 week or
as directed earlier by this court by order date 2/9/2020.
Madam, 2 weeks.
Lordship
Ma'am.
may kindly fix a date, my lord. They have taken several adjournments.
Yes.
Yes, I have given one. After 1 week, registry will give you a date. No worries, Mr. Chakraborty. The difficulty of giving date is because I don't know on that date how many matters are there. So some
Madam, 10
free hand is required to be given to the registry.
Madam.
But otherwise, after next week, it will come.
Madam, immediately after 10 days, because this have to come from the Ministry of MHA. So
No,
some
that,
more
my
than-
lord, Lordship kindly see
Yes,
the last
the last
order.
thing is-
Sixth
All right,
occasion,
all right, all right. 10 days or piece on that date.
Yes.
date, date may come, my lord.
Okay, date after 10 days. But you file it.
Yes, my lord. That's why I'm saying.
First, बहुत दिया सर साइड की बड़े.
Must apply.
তিনি ভালকে মেইনটেইন করবেন নাহলে এন্জিনিয়ার ভাঙি যাবে. Yes,
May it please, Your
some
Lordship.
mediation was there, Mr. Singha.
Yes, Your Lordship. The finance departments are required to file the affidavit that in pursuance to
Yes,
a,
what happened?
there is no affidavit. as of
On 16/9, I have got the instruction, my lord. I pay for at least 1 week's time.
All right, as prayed for by Mr. B. Gogoi, Learned
Finance, my lord.
Learned Standing Counsel Finance, list this matter on
Immediately after vacation, in the meantime,
after vacation on such and such date to enable the finance department to place the report or
no,
to
I will
play,
file my affidavit, my lord.
to play to file return in the matter.
Lordship.
Your Lordship, they will file it before the vacation so that I can file my counter after that.
My lord.
Deeply obliged, Your Lordship.
Compassionate.
Lordship.
When did the applicant's father, mother, who died?
Others died on 22/11/2019.
22,
11/2019
19,
and applied for 22/1/20
22/1/20,
20 lordships.
and then DLC.
So we don't have a DLC, Malad. The APDCL, Malad, has a scheme of its own. But by the time the application was made, Malad, the scheme for compassionate appointment was replaced with the compassionate family pension scheme, Malad. Now, my instructions are the petitioner has already applied for grant of the family pension, Malad. Those applications and all that are under process, Malad. Perhaps that prayer for compassionate appointment doesn't survive anymore, Malad. I placed the notification.
No, you file a
Malad,
affidavit.
I'll file an affidavit, Malad.
Let him file an affidavit then. Mr. B. Chaudhary,
Beach.
Standing Counsel APDCL submits that he has received instructions to the effect that since the earlier scheme of APDCL for pertaining to grant of appointment on the basis of compassionate appointment has undergone a change and has been replaced by
a compassionate family pension scheme, Malad.
by a compassionate family pension scheme, and that the petitioner and that he has received also and that the petitioner has already applied under the said scheme. Stop. However, he does not have the instruction, no, however, the same is still pending. Stop. Let the said instruction be placed by way of an affidavit. List again on.
So immediately after the vacations comes on file. Deeply over.
24.
The Lordship, I sincerely apologize. Actually, the order that has been passed in 22, it should have been in 24.
24. He is appearing in 22.
It was his matter. I'm sorry, Your Lordship.
So 22 order is 24.
Yes.
Yes.
अच्छा भाग दो 22 order to जो 24 for yes
Your Lordship,
and
for 22, it is his matter, Your Lordship. I'm sorry,
yes
my Lord.
it हो गया 22 file के साथ it 22 order to 24
Yes, mediation is going.
one second. That is why I was asking mediation and I was talking about a report.
Mediation is still on.
Why were you all confused?
He came in, so I
Mr.
thought
Gogoi, you recognized your opponent and you
Yes, ma'am.
anyway it happens. Yes, what about the mediation?
The mediation process is going on. Both the parties stay outside. One is from Jorhat, one is from Silchar.
All right,
That's
we'll
why-
post this then after vacation.
Yes, ma'am.
Mr. Your name?
Amen.
Mr. A. Manor, Learned Counsel for the respondent, submits that the mediation is still going on and accordingly seeks some accommodation in the matter. In view of the above, list this matter after 4 weeks on a date to be fixed by the registry. Are you 24 only? Okay, we took some.
Make this. Lordship, here happened, Lordship, there is a Lordship unauthorized absence from duty. Unauthorized absence from duty. Accordingly, he was being dismissed for service. Against the order of dismissal, he filed appeal. During the pendency of the departmental appeal, he died. So, Lordship, after that, his legal heirs came approached this court for providing the pensionary benefits, Lordship. So, Lordship, we have received one preliminary instruction in the matter that according as he was being dismissed for service, so that's why we are not providing you the pension. Where Lordship, in that instruction, it is the reasons of doing so. The reasons were not mentioned in the instruction, Lordship. There's only 3 or 4 lines of instructions.
You want
so
some
yes,
time?
yes, to provide some updated instruction.
My lord, they have received the instruction on my lord 7/6.
Yes, but he has gone through the instructions and he finds that there are certain more instructions required.
My lord,
So
because
let him get it.
this was happened, my lord, in the month of June itself, my lord.
Correct, but if you see, the affidavit is required for an effective adjudication of the matter. So you have to be patient.
My lord.
It's a 24 matter.
My lord.
Yes, Mr. Your name?
CKS Borwa,
As prayed for by Mr. CK. Mr. CKS Borwa, learned government advocate, Assam, submits that though instructions in the matter has been received, however, the same is not adequate for filing the return in the matter. He accordingly seeks some accommodation in the matter. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Item number 16.
Where is Mr. Handik?
Copy has been served. Extra copy has been served.
John Thakile Matilo. Let both be there. Let him be there. Yes.
Your Lordship, actually my senior Mr. SP Chaudhary is having some medical emergency today, so kindly fix it on Monday, Lordship.
My lord, it is okay, my lord, but we have some till Monday, my lord, status quo should be maintained. Otherwise, by Friday night they will.
This is that regularization matter.
My lord, yes, my lord, there is a direction of this honorable court to consider.
Where? So, where is that direction?
My lord, page 135, my lord.
One.
Page T, annexure T, my lord. Annexure T, page 125. So, pursuant to that, they consider 125, my lord. Annexure T. Its operative portion start at 129. And My lord, direction is given, my lord, in 134. Ministry- 34. my lord. Yes.
Four.
Yes. Because their matter is in pipeline since last 25 years. And Umadevi case is also not discussed. That is why we have challenged the communication annexure U135. All wrong facts has been considered. That is the reason why.
Your lordship may consider it on Monday, lordship, as I don't have any instruction with regard to that, lordship.
Page 136, Uma Devi's case specifically mentioned. So our case is covered by that. That is not considered. That is why we have filed. Para 7. And annexure CD, we can show that they are through due process, and Uma Devi says that employment exchange also a mode of advertisement. Then it may be irregular, not illegal. So irregular, if it is illegal, then
What
also
is
they
this
have some-
communication 5924?
Yes.
What
Annexure-
communication is that?
It is annexure 135. This is direction is given to Ministry
That
of.
you are not entitled for regularization.
No, they have to consider it. That is direction, and they consider it, and some wrong facts has been given.
Mr. Counsel, why is it so difficult for to just simply answer what I'm asking? That
Yes.
5924,
Yes.
that communication, in that communication, what is that communication? Because as per your prayer, it appears that the Government of India, Secretary to the Government of India has mentioned that daily wage workers of NIT Silchar are not entitled for regularization.
Yes.
Correct?
Yes.
This is the obstacle.
Obstacle.
This
And-
is the obstacle.
Yes, and ground is we are not acceptable because they said we are not working against the sanction post. But record says last 30 years we are in a sanction post.
Mr. You have two options. One, I can simply keep it for Monday, or I can hear your interim and dispose
Oh,
it
my
off.
lord, my learned friends requested me can with his presence maybe hurt.
So then Monday, nothing more.
No, only one my humble prayer.
Nothing more.
Because they-
as prayed for by Miss
B. Devi,
P.
lordship.
Devi on the ground that the Mr.
Mr. S.P. Chaudhary.
S.P. Chaudhary,
Yes.
who is leading the, who is appearing on behalf of the respondent, is is indisposed, list this matter again on Monday. Considering the urgency canvassed by the petitioner, list this matter again on Monday.
My lord,
I-
till then, my lord, some otherwise, my lord, they by night they will give it effect to. Then matter will be infectious, and their name also shown.
I can dispose of your interim if you want. That is why I have given you the option. Yes.
Obliged.
May I please, Lordship? This is regarding, my lord, unfilled vacancy of ESM candidate from, my lord, non-ESM candidates, my lord.
They have the instruction awaited, lordship.
Awaited.
Yes,
Let
lordship.
them file.
Date may be fixed after vacation, my lord.
Why you are always wanting a date?
After vacation, my lord. After
Yes,
vacation.
I'll give it after vacation. Registry will list the matter as directed. As prayed for by MS.S. Borwal, learned CGC, comma, list this matter after 3 weeks on a date to be fixed by the registry to enable the said respondent to file the return in the matter.
Obliged.
Obliged. Interim order may be continued. Interim order is
Interim order, if any, shall continue till the next date of listing.
obliged.
May I please, your
Yes, Mr.
lordship?
Datta?
Lordship, in item number 29, 30 and 31, we are filing the affidavit during the course of the day. lordship.
29?
29, 30 and 31, lordship.
Okay.
And in item number 32, we'll be filing it by Monday, lordship.
My lord, so far 28 is concerned.
Pleadings are
My lord, the
complete.
pleadings are, my lord, complete. So your lordship kindly take it on Tuesday. My lord.
29, they are filing it today. And 30 also they are filing today.
Filing today,
32 they will file on Tuesday. What is so auspicious about Tuesday? Why not today in 32?
Lordship in 32.
You are appearing.
Yes, Lordship in 32, I had sought for appearing in the examination. So, in the interim only, I have been allowed to appear in the examination.
No, I'm simply posting these matters on Tuesday.
Yes.
Lordship, can it be on Wednesday, Lordship? Wednesday or
Wednesday?
On Thursday.
Thursday? MS, yes.
So far item 28, your lordship take it on Tuesday.
No,
Other
no,
matters.
let us have it all together. It doesn't make sense otherwise. They are all a series matter.
For Thursday because we may have to file a reply.
Correct.
Since our matter is ready in all respect, so this matter may be
Mr.
segregated.
Doctor, since it's all tagged, it's not that I'm keeping it after vacation. It is kept next week.
All right.
MS?
P. Sharma, Lordship.
P. Sharma. MS P. Sharma, learned counsel appearing for
APSC, Lordship.
standing counsel.
Lordship, on behalf of standing
Learned
counsel.
counsel appearing on behalf of the standing counsel APSC submits that affidavits in WPC 3346 of 2024, WPC 3356 of 2024 and WPC 3475 of 2024 shall be filed within the course of the day. Stop. She further submits that that affidavit in WPC 3525 of 2024 shall be filed on Tuesday, i.e. day to day. Mr. S. Datta, learned senior counsel, assisted by Mr. DJ Medi.
Yes.
Learned counsel for the petitioner submits that as far as WPC 3505 of 2024 is concerned, the pleadings are completed. Stop. In view of the aforesaid, let this matter be relisted on Thursday, i.e. so and so date for further consideration.
Much obliged.
Yes. Counter. Counter is not there.
This issue has been dealt with. This issue has been dealt with by this.
Affidavit is required.
Lordship, this is a single bench judgment relying on a division bench judgment saying that regularized work charge employees cannot be eligible for promotion because they are not governed under any rules that give them the right to promotion.
Lordship, my prior affidavit is required. Here is the present case.
File affidavit.
Affidavit is required. Lordship. I will contribute.
Yeah, give him a chance.
We'll file.
Mr.
I bought her.
Sorry. Mr. I. Thakur, learned standing counsel, PHE, submits that the present case is covered by the judgment delivered by this court, by the coordinate bench of this court in the case of Nibon Chandra Das versus State of Assam and others in WPC 5579 of 2023. However, Mr. So and so, learned counsel appearing for the petitioner disputes the same. Be it as it may, it appears that the respondents have not filed their return in the matter. Let the same be filed within a period of 3 weeks from today. List this matter after 3 weeks on a date to be fixed by the registry.
Lordship, there is an interim order.
Interim, if any, shall continue till the next date of listing.
Oblige.
Lordship, we have received instruction, Lordship.
You'll file as prayed for by MS.
A. Talukdar, Lordship.
A. Talukdar, learned government advocate for the state. List this matter after
3 weeks, Lordship.
After 3 weeks to enable the government to enable the respondent to file their return in the matter. To file the return in the matter.
I have filed an IA, Melody.
There is an IA.
Yes, Melody. Already, Melody.
What is the IA for?
IA, Melody. Already, result has been declared, Melody. Selection has been published during pendency of the requisition, and we are continuing service on 3F regulation, Melody. Since 2022, Melody. And at present, Melody, if the appointments are made, Melody,
But then this is a distinct cause of action. How can it be pressed by way of an IA?
Already, there is a prayer for interim prayer in the repetition itself. To stay the advertisement, which
No, but results are out now. Results are out.
Results have been out.
Correct. So
Yes.
if so that
Now,
means
our prayer is either to stay the advertisement, otherwise we will be affected.
no, results are out.
Results are out during pendency of the repetition. And that
Well,
is why
in the writ petition, there was no stay.
There is no stay.
there was no stay.
Then-
And the prayer of
And
stay is already there in the writ petition.
Now we have filed this IA. We are continuing.
No, in the IA also you filed your affidavit. IA and WPC দুটা কৰি দিয়ে, একেলগে কৰি দিয়ে. Let them file their
If
return.
it is disposed of earlier,
No, you did not get stay.
I'm submitting on
Mr.
the
Council, the difficulty is that this court did not stay the advertisement on the first day.
Yes.
So,
Results are also out.
now after the results are out, anyway, I'm not disposing of your IA. If you insist, I can dispose it of today.
Our services are extended till April 25. And in
All
the
right.
meantime,
Next matter.
Not is the lordship. This case, whatever. I challenge,
Suspension.
yes, I challenge the suspension, but during the suspension period, I got retired on 31/8/2024. But at this stage, only one thing remains. Otherwise, it's
Subsistence allowance.
Yes, subsistence allowance I got, my lord.
Then?
Here, my lord, because I challenge the suspension order. If the department finds the suspension order is illegal, whatever may be, what the department finds, then the suspension period may be treated on duty, my lord. That is 54 FR.
Anyway,
54.
return has not been filed, Mr. Bhattakur.
Lordship. Our instruction, before we could get our instruction, Lordship, the petitioner already retired.
Yes, but suppose that suspension period was illegal, whether periodical reviews were done, not done.
Not done.
So if it was not done, then Ajay Chaudhary comes in.
After 9 months, they have proceeded.
You following what I'm
Yes.
asking?
Yes.
I'm pointing out. So you,
What I would suggest is that because there's a provision to regularize the suspended period even after retirement, let the petitioner approach the authorities, Lordship. They'll consider, and if required, Lordship, they'll regularize the period of suspension.
Then his submission may be recorded.
Under 54B, Lord. They'll consider, Lordship.
under
FR 54B, Lord.
FR 54B. Some
This one I have.
But who is the petitioner? The petitioner is the person who has died.
Retired.
Retired.
Retired. May I read, my lord?
1 second.
Page 54B. FR 54B.
FR 54B. Yes, please read.
Yes. When a government servant who has been suspended is reinstated or would have been so reinstated, but for his retirement on superannuation, while under suspension, the authority competent to order reinstatement shall consider and make a specific order regarding pay and allowances to be paid to the government servant for the period of suspension ending with reinstatement or
So
the
then
day-
I can dispose it of saying that
Yes.
let him approach before
Yes,
the
yes.
competent authority and let them take a call under FR 54B in
54B.
accordance with law.
Yes, sir, that would do.
For disposal, no? 35. Heard Mr. A. Chaudhary,
My lord.
learned counsel for the petitioner. Stop. Also heard Mr. I. Bhattakur, learned
Council for Forest
learned
Department.
standing counsel,
On behalf of standing council.
learned counsel for respondent numbers
All the respondents.
for the respondents. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is challenging the order dated 23/8/2023, whereby the services of the petitioner was placed under suspension pending withdrawal of departmental proceedings on being arrested on 23/8/2023 by the Directorate of Vigilance and Anti-Corruption, Assam. It is submitted at the bar that during the pendency of the writ petition, the petitioner has retired from service. It is further submitted at the bar that in view of the superannuation of the petitioner, FR 54B the case of the petitioner can be considered in the light of FR 54B. Stop. Next paragraph. In view of the aforesaid endorsement made by the learned counsel for the parties, this court deems appropriate to dispose of this writ petition with the direction that with a liberty to the petitioner to approach the competent authority in terms of FR 54B, and as and when such application is made before the competent authority, the same shall be disposed of in terms of FR 54B within a period of
30 days.
30 days from the date of receipt of the said application. Stop. Ordered accordingly, disposed of. Obliged. Okay.
Lordship, I pray for 2 weeks' time to file my counter, Lordship.
This matter can be disposed of, Lordship.
I was wondering why so urgent. Before even she could reach, she started making that prayer. Why disposed of? Why disposed of? It's covered by Sanjita Roy.
Lordship, time and again the AG has returned the proposal to our department, Lordship. It is the AG who has not. Lordship, may kindly have a look at page 27, Lordship.
1 second. Pension proposal.
Pension, Lordship.
We can similar direction.
Yes, but the accountant general has for 3 times sent the proposal to the parent department, Lordship. That is the problem.
Why do you all find out? Because there is this order, we will direct it. You sort out your internal problems.
Yes.
Only we'll examine as per Sanjita. We'll examine as per Sanjita.
Yes, I will. Same thing. The in terms of Sanjita Roy.
Yes, yes.
Item number heard Mr. S.D. Purkashta, learned counsel for the petitioner. Stop. Also heard MS.
Arbora, Lordship.
Arbora, right?
2, 5,
BORA.
BORA-H.
BORH. Arbora, learned standing
Council, Agriculture Department.
Standing Council, Agriculture Department. A. Chaliha, learned standing council, Finance. S.K. Medhi, learned standing council, AG. And A. Talukdar, government advocate for the state respondent. The same submission. It is submitted on behalf of the petitioner that though the services of the petitioner as a master role worker was regularized only on the ground of non-fulfillment of 20 years of continuous services as a regular employee, the pension has been denied. Stop. The
She was engaged on 19/5/92.
Hmm?
She was engaged as mustardul author on 19/5/1992.
Heard the learned counsels for the parties. Stop. It appears that the petitioner's services was regularized with the order dated
5/10/2005.
5/10/2005, issued by the respondent number
Director Agriculture Law.
5.
number 5, with effect from
With no engagement law.
with effect from the date of engagement. Stop. He's retired.
Retired on
Petitioner retired from service on
30/10/2016.
30/10/2016.
16.
It appears that the petitioner's grievance is that despite the pension proposal of the petitioner being submitted to the respondent number 4, no final decision has been taken by the respondent number 4 with regard to the grant of pension to the petitioner. It is submitted at the bar that the issue raised in this writ petition is covered by the decision of this court in the case of Sanjita Roy and others versus State of Assam and others, reported in 2019, volume 2 GLT at page 805. Stop. In view of the aforesaid endorsement made by the learned counsels for the parties, this court deems appropriate to dispose of this writ petition in terms of the judgment of this court in Sanjita Roy within brackets Sutra. Next paragraph. Resultantly, respondent number 4 is directed to take a decision on the petitioner's pension proposal within a period of 3 months from the date of receipt of a certified copy, if a copy of this order. Stop. The terminal amount paid to the petitioner shall be adjusted against the pension payable to the petitioner. Writ petition accordingly stands disposed of.
Obliged.
Much of this.
Nikita, 39.
Instruction essay.
42. Yes, Mr. Talukdar.
We have received instruction, Lordship.
Can you file an affidavit?
Lordship,
Yes.
As per the instruction, Lordship, the second para of the instruction,
Yes, after tabulation.
after tabulation, it was found that the total mark of the deposit Gogoi is less than the cutoff mark in his category even after giving 2 marks against his certificate, where the period of service SPOs was not specified. Hence, he is not eligible to get an appointment in connection with the requirement of 154.
You put it by way of an affidavit.
Yes, madam. Let them have it.
You can't take the petitioner by way of a surprise.
Yes, madam.
MS A Talukdar, right? A Talukdar, Learned Government Advocate, submits that she has received the instructions for filing for filing counter in the matter and accordingly seeks 2 weeks time for doing the same. Prayer is allowed to list this matter after 2 weeks on a date to be fixed by the registry.
Much obliged.
Deeply obliged, Lordship.
Yes, Ms.
Then
Dan?
it speaks for
Affidavit.
interim pair. Madam, that may be fixed on Friday. Madam, I didn't receive any instruction till now. That next Friday for interim pair on.
All right.
Friday,
As
Thursday.
prayed for by MSA Gayan, Leonard CGC, list this matter on such and such date, Friday date, for filing the, for obtaining the for placing the instruction as called for earlier by this court by order dated 2/9/2024. Stop.
And next week, my Friday evening.
Yes.
Yes, Friday.
Friday.
Must have.
Technique was well, 44, 64. Yes, rejoinder.
No, we will not be filing any rejoinder. In fact, on the last occasion, we had submitted on.
May I please your lordship? Lordship, Mr. Dipivara, due to some medical emergency, he had went to GMCH lordship. So he's coming. He's on the way to court lordship. This matter may be taken up at 2.
2, there is a matter of the Isol bench also fixed. Monday,
Lordship, Monday I'll not be available after vacation. Lordship, let it come out after vacation.
all right. It is submitted that Mr. D.P. Bora, Learned Standing Counsel, Health Department, due to a medical emergency, had to leave the court premises. Stop. In view of the above, list this matter after
Vacation.
after 3 weeks.
Yes.
After 2 weeks on a date,
Yes, after
on
2
a date
weeks.
to be fixed by the registry.
Lordship.
Deeply obliged.
The petitioners are presently.
In item 65.
In this case, yesterday we filed affidavit, my lord. for
Respondent
the
number
You have
case.
filed.
Yes, my lord.
I don't
Not
think
in-
the
not-
affidavit is on record.
Not in record, my lord.
Yes, I
as
have
per
received
affidavit.
the copy. Only
Huh?
respondent number 3, AZ, has filed. The state has not filed, and
But we
private.
can't force if state doesn't want to file. Yes, state. Are you filing anything, Mr. Alukdar?
And private respondent is there, service complete.
Service completed.
Yes, yes, yes.
Are you filing any rejoinder to the
Yes, yes.
affidavit?
I'll pray for 2 weeks' time for filing affidavit in that.
Your name,
Yes, sir.
as prayed for by Mr.
Yes, sir.
S. Nath, Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder to the counter affidavit filed by respondent number 3. Stop. In the meantime, the other respondents, if so desire, may file their returns.
Obliged.
My lord, name may be recorded, my lord.
Your name is already there.
My lord, it is difficult. Sometimes they.
It is there, SK Medi.
Yes, my lord.
So where do you want your name?
Orders, my lord.
Order I have said no. Equal. Huh? As prayed for will call agent. No, ठीक है सर. ऊपर को.
Obliged, Lordship.
Yes.
I think item number 16.
Yes. So I'll allow the IA. It's for modification of some of the prayer, right, Mr.
Yes,
Chaudhary?
prayer, ma'am.
Heard Mrs. M.D. Chaudhary, Learned Counsel for the petitioner. Stop. Also heard Mr.
P. Handic, my lord.
P.
P. Handic.
Hendick, Learned Standing Counsel, PNRD, and Mr. CKS Borwa, Learned Government Advocate for the state. Stop. Itu hi IA. Take IA task.
Main petition. Main petition.
By
No.
filing this application, comma, the petitioner is seeking modification stroke amendment to the prayer of the writ petition, to the prayer contained in the writ petition, i.e. WPC number 4252 of 2024. Stop. It appears that due to bona fide mistake, due to an inadvertent error, comma, some relevant dates and sentences were dropped in the prior part of WPC 4252 of 2024, comma, for which the present application has been filed. Respondents, Learned Counsel appearing for the respondents, submits that they do not have any instruction to object to the said prayer. Stop. Accordingly, this court, for the ends of justice, allows the interlocutory application by directing Ms. Chaudhary, you said prayer, but it appears a lot many paragraphs you need.
No, my lord.
Huh?
Only the prayer.
Where is which
para
is
4,
the
my lord, para 4.
para?
4. Only this much. Raise the continuation. my lord.
That paragraph 3 or 4?
4.
4. According
3 and 4. Then 4, I have added everything, my lord.
By directing to replace the existing prayer
3 and 4.
in WPC so and so with page 7 of Paba. 3 and 4, correct?
Yes, ma'am. Yes.
Page 6 of Rasa. 6 of Pra, exam, page 8. Or you do one thing, the 6 of 8 go by para 5 of us. Para 5 of us, no? Allowing the amendment motivation of the prayer as stated in paragraph 3 and 4 of the instant application, which shall read as follows. Okay? A to A, page 9. Page 9. I will read it. What objective? It appears that paragraph 3 and paragraph 4 of the paragraph 2, 3 and 4 of the interlocutory application is reproduced here under for ready reference. Third column. Reading of the aforesaid paragraphs apparent that due to inadvertent mistakes, due to inadvertent mistake, error crept into the prayer made, and accordingly, in the interest of justice, it has become necessary for correcting the same. Allowed to go.
Do I have to
Disposed of I.
my lord, do I have to file an amended?
You will, but I think this is, you'll have to file an amended petition.
My lord, only the page may be changed, my lord. Only the last portion, my lord.
No, this is not a cause title.
Prayer page, my lord. Because I have
Let
not
an
added
amendment
any.
petition be submitted by the petitioner to the registry for doing the needful. You file the entire petition with a copy to the other side.
Okay.
You see, this is not a cause title, Ms. Chaudhary. So you file an amended petition.
It's okay. And can it be date fixed? my
First,
lord?
you file in the writ petition in view of the order passed in ISO. Let this petition be listed after 3 weeks on a date to be fixed by the registry. Yes. Next matter. Yes, Mr. Becca, why is this matter for orders today?
Lordship, without complying the order judgment passed by this court, honorable court, two of the respondents have filed their affidavits. Now, Lordship, kindly see here, the petitioner was a UDA in the Kanpur Town Committee.
You was a
UDA.
UD.
Then this chairman, he issued so cause notice. Then subsequently he was suspended, and during a departmental proceeding, it was his service was discharged. He was discharged from the service. So the petitioner approached the honorable court in 2011, and the petition was disposed of on 19. He was suspended in 2007. Till 2007, till today, he has not got anything. Even there is a area subsistence allowance.
Where is
Now,
the operative part of the
yes,
order?
Lordship. Now here, operative part, Lordship, the judgment is at page 11, and
17.
relevant part is at
17.
page 17, relevant part.
12.
Before para 12, because two affidavit has come, so Lordship kindly see what is their stand before the court. Paragraph 10, Lordship.
Paragraph 10.
10.
Yes, please read.
Learned Counsel for the Town Committee, however, submitted that it has been specifically mentioned in para 11 of the affidavit in opposition of the respondent number 6 and 7 that it has been categorically denied that the authorities had failed to furnish the document and list of witnesses to the petitioner. However, original of the said affidavit does not indicate as to when the aforesaid list of document and witnesses were furnished to the petitioner along with the show cause notice, and as such, the aforesaid mere denial does not satisfy the requirement of law. Para 11. It is submitted by the learned counsel for the respondents that all the procedural requirements were followed, and further the post of UDA has been already filled up by the another person. Why I'm placing this, Your Honor, because they have taken some different stand in their affidavits. Now 12. After hearing the parties and considering material on record, this court is of the opinion that present petition can be disposed of by setting aside the impugned discharge order dated 23/7/07. However, the authorities would be at liberty to proceed, if so advised, from the stage of furnishing of the so-called notice by giving a list of the witness as well as document. However, this is important, Lordship. First thing. However, the petitioner will be entitled to reinstated to service.
They have not reinstated you.
No.
Why? There's a
There
positive
are other-
direction.
Yes. I'm coming to that also. Their affidavit they have. What they
No,
have.
affidavit, I shall go, but if you have any grievance, you could have filed an appeal.
Yes.
Because as far as this order at paragraph 12 is concerned, there is a positive direction to reinstate the petitioner. Have you done it or have you not done it? Please answer. Yes or no?
May I submit, Lordship?
No, first yes or no.
Lordship, actually,
It's a very direct question, Mr. Counsel. Yes or no?
Definitely not.
Then why? Because if you have any grievance, you could have gone for appeal. Have you gone for an appeal?
No.
Then,
Lordship, what
since
happened-
when has the authorities started interpreting the orders of this court and act as they please?
Lordship, I was appearing on behalf of the respondent number 6, but last year itself they have taken back the brief from me, Lordship.
Now, who is the person, main person,
6,
respondent?
respondent number 6.
Who is appearing for R6?
Now at present they have not filed any wakalanama. In fact, when the last
Very difficult. It is very difficult when such things happens.
Yes.
You had entered appearance once.
yes. Because last week when the matter came up, then also I informed them over telephone, because it seems no one has entered appearance. And in fact, that lordship, that order dated.
Where is that affidavit, Mr. Decca, that you wanted to show?
Lordship, their affidavit.
R6 affidavit is there.
Yes, sir. Respondent number 6. But before that, Lordship, at the relevant point of time, respondent number 4 was there. Respondent number 4 also filed their affidavit.
What do they
And
say?
Lordship, he was in the office of chairman till 6/4/2020, and he annexed one resolution here. Only took a resolution, Lordship. That is at page 33 of that.
Page
33, Annexer A. And there is no whisper, Lordship, regarding the reinstatement.
No, you please, because you see, Mr. Decca, I'm considering to pass some
Yes.
adverse orders against R6. That is why I'm asking you to point out this.
Yes.
Please point out where it is, because the first thing is that there is a very positive, unambiguous order of this court.
Yes. Now, Lordship, if Lordship,
Orders of this court cannot be
yes.
dealt in such fashion. Yes.
If Lordship come present incumbent, the respondent number 6, they have annexed some document, Lordship.
No,
annexed
one by one.
Yes.
You are referring to two affidavits, right?
Affidavit.
First, show me R4 affidavit
Yes. R4.
and that paragraph.
Yes. R4 affidavit, Lordship, Annexer A. At page 33.
33.
3.
One second.
Because at that relevant point of time, the R4 was
1 second.
in office.
Anyone appearing for R4? Thirty.
3. Annexer A.
No, I'm not getting it. I have R6 before me.
Yes.
R4 is Lalit Bharali.
Lalit Bharali, Lordship.
Yes, page.
Page 33, Annexer A. R33 is the translated copy. Vernacular is there.
Yes, please read.
Lordship, it is a meeting held on 31/5/19. Today in the meeting, the President of Kanpur Municipal Board apprised about the letter dated received from Guwahati High Court bearing letter number WPC so and so dated 1/3/19 in connection to the High Court matter, Sri Girish Bora, and solicited suggestion from every member present in the meeting. Every member present in the meeting discussed the matter in detail. The President requested all members to give opinion and found that Sri Girish Bora was dismissed from service in the board meeting of 2007. All members present in the meeting discussed the matter minutely, taking note of the financial hardship of the Kamputa Municipal Board. Therefore, honoring the direction issued by the Honorable High Court, the board resolved to grant all benefits as per the High Court direction to Girish Bora as soon as financial condition of the Kanpur Municipal Board improves or financial grant of government ration received. All members present in the meeting and agrees
What
to
kind of a resolution is this, Mr. Kotogi?
There is no score of
What
this.
kind of this? What is this resolution at page 33? They are talking about compliance of this court's order as soon as financial conditions of the Kanpur Municipal Board improves. What about the reinstatement?
My
Please
lord,
read it.
probably that's probably this is the people representing the
No,
board.
but you are an officer of
No,
this
my lord,
court.
I
You
am
tell
officer-
me
officer-
whether the order of this court has been complied
No,
at page
by this
33.
way, so far that part is concerned,
Reinstatement. That is only this court is concerned right now because that is a positive direction.
along with the financial benefits are also there.
But what
My lord,
about the reinstatement? Where is it mentioned in page
lord,
33?
That
And
that's the difficulty, my lord. What happened? This board is the authority under the statute, my lord. Board has to take a decision so for the appointment and salary.
see,
I cannot do it of my
see,
own. my
Mr.
lord.
Kotoki, if there is any inconvenience in following the orders of the court, remedies are available.
No, I do
Correct.
agree, your lord. I appreciate that.
But
my lord,
how can it be said that benefits as per court's direction as soon as financial conditions improves?
my lord,
What is this kind of languages? When there are positive instructions of the court, if you have a
my lord,
financial
my lord,
problem,
my lord,
come before the court
probably they have
by
the-
way of an appropriate application.
No, but I do agree with you, lord.
No, in that case, let R4 and R6 both be personally present before this court on the next date and explain what is happening. I will let the registry intimate R6 about the court's order, about today's order.
Even
Both
the-
has to explain.
R5
They can appear through virtual if they desire,
I do.
but both will have to appear because R4 was there at that relevant
At
point.
that
of time.
time, Arthur was there. You know, he's an elected person, and
Hmm?
he was the chairman of the board. You know, that I undisputed fact. You know, there's a difficulty. What I find here, the board, I cannot direct the board or to do it,
No.
but the entire board is the responsible.
Correct, but in that situation, you could have apprised the court.
No, my lord.
You could have filed an appeal.
No,
Where have you
because the intention
on
of-
your part have you
I-
communicated a letter to the board?
no,
Show me a
due-
letter.
With due respect, my lord, what I find from here, because you know, they are not legal expert, they are just general public.
No.
Look, what I find from
Mr.
this,
Kotoki, you don't need a legal expert to understand the
No, mere-
unambiguous order of this
unambiguous,
court.
that part I am totally agree with you, Lord.
I am only on that.
I am totally
I'm
agree
not
with you,
on
Lord.
the other issues right now.
I'm not
There is
disputing
a
it.
clear order of this court
I'm not-
for reinstatement.
I am not at all disputing your lordship.
And till 2024, the petitioner has not been reinstated in service. Correct, Mr.
He
Dekam?
already
Retired.
reached the age of
No, my lord,
supervision.
what I find from it that they have examined the matter, and as soon as reinstated, my lord, they are probably what they are in mind.
Anyway, where is respondent number 6 affidavit?
Lordship,
In which
respondent number
para?
6 affidavit, similar resolution, Lordship, at page 38. Same, Lordship, financial district.
And in the body also nothing about reinstatement.
No, that was nobody whispered about regarding that. They
Here
have
it is
discussed
33.
38, Lordship, relevant portion. Translated copy is given. Same modus operandi, Lordship, same thing going on.
Page
Page
30.
38, Lordship, respondent number 6 affidavit. And interestingly, Lordship, till today, how much I am entitled, that is even not calculated, not informed.
Right. When was the brief taken from you?
Last year, Lordship.
Last year.
Yes, because
Any documents?
that document, Lordship, I do not have, but that honor.
As of now, we are not saying anything of R4, but as far as R6 is
The
concerned,
order dated 38/2000.
Direct either present incumbent or what is the amount, total amount he is entitled.
see, that is secondary. First, what about his reinstatement? Why did they
No,
not do it? So I will not say
No,
anything.
what I find here, that he has already been retired according to him. So he will be getting the benefit, entire benefit.
Financial.
And that will be the responsibility of the town committee to pay him, to compensate him the entire
So financial benefit.
financial gain, whatever he is entitled. And that will, when either he will be benefited to get the entire money. That
All right, you just hear out. Let me just indicate.
that will save his
Yes,
entire.
Mr. Deka.
Lordship, may
As
kindly-
per last order, respondent number 5 also is involved in this whole
Who is
process.
5?
Five is
Mr.
appearing but
Deori,
not
you have been
filing.
very silently sitting.
Not filing. Now, for a moment, Lordship, kindly see the 38, because their intention is also, because today also, 38, page 38, what is their intention? Because the order is violated till today, day-to-day violation is going on. What is their intention? Today, that is on 16/8/23, Wednesday, a meeting was called for in the office of the Kanpur Municipal Board. During the discussion in the said meeting, it is found that there is no records regarding the action taken by Sri Lolit Bharali, the earlier chairperson, and then executive officer of the Kanpur Municipal Board, that is respondent number 5. Compliance of the order dated so-and-so, passed in so-and-so, filed by Girish Bora. Therefore, discussion has been taken today in the meeting to inform government regarding the payment of the entire amount payable to Sri Girish Bora as per Honorable Court's order dated 1/3/23.
All right,
passed
Mr.
by-
Deka, hear out the order.
Yes.
Heard Mr. J. Deka,
Yes.
Learned Counsel for the petitioner, stopped. Also heard Mr. No. First, S.R. Borwa, Learned Counsel appearing for respondent. 6, Mr. S. Kotoki, Learned Counsel appearing for respondent number 4, and Mr. D. Deori,
B. Deori.
B. Deori, Learned Counsel appearing for respondent number
5.
5.
Lordship, may kindly peruse this, the order of this court in this context.
Lordship, just from with respect to respondent number 4,
It's all right. I'm not.
yes, he's no longer in service there.
I'm not saying anything about the
Yes,
other respondents as of now.
Honorable Court's order dated 38/23, it was personally received by the respondent number 6, Lordship. Last opportunity was given by that order, Lordship. Although I was
This is R6.
R6. Okay.
The instant contempt petition has been filed for non-compliance of this court's order dated
1/3/19. Page 12. One order.
Change.
Page 12 is the order dated.
Back it. Order dated
1/3/19.
1/3/2019.
1/3/2019. WPC number
In
1279.
WPC number
1279/2011.
1279 of 2011. Stop. Mr. S.R. Borwa, Learned Counsel, appearing on behalf of the respondent number 6, submits at the outset that the respondent number 6, who is the present chairman of the respondent board, has taken away the brief from him.
This is not the NOC. I have intimated her about the last that order dated.
Yes, okay. Almost a year back.
Yes.
And he has already, pursuant to the court's order, pursuant to this court's order on 30/8/2023, informed R6 as regards the next date of listing of this contempt petition. Stop. However, it appears that respondent number 6 has not taken any steps to re-engage any other counsel. Stop. It further appears that this court, where is the order of this court? This court, while disposing of the writ petition
17
WPC 1279
Page
of
17.
2011 by order dated 1/3/2019, was pleased to direct the respondents number 6 and 7 was pleased to set aside the impugned discharge order dated 23/7/2007 with liberty to the respondents, if so advised, from the stage of furnishing of the show cause notice by giving a list of the witnesses as well as the documents, to proceed. Stop. It further appears that this court further directed the respondents to reinstate the petitioner to service and face the departmental inquiry afresh in terms of the observation and direction made therein. Stop. Relevant, apt to refer to paragraph 10, 11, and 12 of the aforesaid judgment, which is reproduced hereunder for ready reference.
15 is also important. Time frame was given 15. 6 months time was given to complete. Otherwise,
Reading of the aforesaid paragraphs, apparent that this court had unambiguously directed the respondents to reinstate the service, to reinstate the petitioner to service and face the departmental inquiry afresh, if so held, and has further directed that the said exercise to be concluded within a period of 6 months from the date of the court's order. Stop.
last line, Lordship, accordingly.
It further appears that this court was further pleased to observe and direct that failing holding of disciplinary proceeding and concluding within the time frame granted by this court, it will be deemed that the authorities are not keen to proceed with the departmental inquiry, and accordingly the same shall be closed and the petitioner will be granted with all the consequential benefits. Stop. Mr. J. Dekan, learned counsel for the petitioner, submits that admittedly the petitioner was not reinstated in service as directed by this court by order dated 1/3/2019. He further submits that pending adjudication of this contempt petition, the petitioner has retired from service.
Yes.
Stop. Before proceeding further to the contentious issues raised in this contempt petition, it is apparent that the services of the petitioner was not reinstated in terms of the direction passed by this court's order. dated 1/3/2019. At this stage, apt to refer to the affidavit filed by the respondent number 6, wherein a resolution has been enclosed
Their statement at para 5, case 4.
I'm trying to find that
38.
affidavit. Yes, I've got it. Para
And-
5.
Para 5, they have mentioned a relevant portion is at
here we-
38.
keep it in
Can see
Michila.
that copy of this resolution.
Apt to refer to the affidavit filed on behalf of respondent number 6 on 21/8/2023, wherein the said contemptor has stated that upon discussing the issue of compliance of this court's order dated 1/3/2019, a resolution was passed on 16/8/2023, wherein it was unanimously decided that considering the aspect of revenue collection of Kanpur Municipal Board, the board is not in the position to pay the entire back wages to the petitioner from the own source of revenue, so the board will come to the government for sanction of fund to the board, and as soon as the government releases the sanctioned fund to the board, and accordingly the back wages entitled to the petitioner will be paid, and in this regard all the members do not have any objection. Stop. A copy of the said resolution dated 16/8/2023 is reproduced hereunder for ready reference. B2B, page 38. Yes, on 16/8/2023, were you in service or you retired?
No, Lordship. His date of superannuation is on 28/02/2001.
28/2001.
2001.
At that time, R6 was not
Not there.
there.
R4 was there.
It appears that
Lordship, 2021. Sorry. 21.
2021. Apparent, it is Mr. J. Dekal, Lieutenant Counsel for the petitioner, submits that the petitioner retired from service on 28/2/2021. Stop. It appears that this court further it appears that from the affidavits filed by both respondent number 4 as well as respondent number 6, as indicated above, does not contain any averments as why petitioner was not reinstated in service as directed by this court earlier by order dated 1/3/2019 in WPC number 1279 of 2011. This court finds that there is prima facie non-compliance of this court's order dated 1/3/2019 by the respondents. Further, due to the non-appearance of respondent number 6 by re-engaging a new set of counsel, this court is not being able to proceed further in the matter. So, situated thus, this court directs personal appearance of respondent number 6, within bracket, Srimati Dhoritri Borua, comma, Chairperson Kanpur Municipal Board, comma, Kanpur, comma, Nagaon, before this court, either through video conferencing mode or personally in court on date. Date.
Yes, your worship.
Give me a date. After vacation at the on such and such date, stop. Let registry intimate respondent number 6 and I so and so about the order of this court. Hmm? Registry will inform. I don't think because you are not there anymore.
No.
Petitioner is also at liberty to inform to take steps to intimate respondent number 6 as regards the next date of listing and today's order by registered post AD.
Right.
You also inform.
Yes.
I'll edit the order. I am not saying anything about Arts 4 or R at this moment, but it appears financial burden. You cannot simply say that and sit.
I have transferred from them.
That's why you all be ready.
I'm no longer there.
Oh, you are transferred.
Yes.
New incumbents have been brought in or not?
Maybe so.
But
The recent recruitment.
is in continue, Lordship.
No, correct. But if any new incumbent needs to be brought in, then Mr. Deka, before the next date, you
Followed or not, it's not written. It's written here that on 14/6/2023, the petitioner was arrested along with a huge quantity of heroin. And
petitioner was arrested.
with one
I'm sorry, I can't hear you. Petitioner was arrested.
with a huge amount of heroin.
Quantity is large.
Yes, my lord.
Yes.
And my lord, packing and sealing of the suspected heroin were done in the presence of civilian.
Please adjust the microphone. Yes.
Yes, my lord. And packing and sealing was done before civilian witnesses.
What was done?
Packing and sealing of heroin.
Packing and sealing.
Yes, my lord.
Yes.
And that is on 14/6/2023. And on the next day, that is 15/6/2023, prayer for judicial remand was made to the CJM. And here, my lord, drawing of exhibit samples was conducted before the court of the CJM.
Prima facie, it was all done.
Yes, my lord.
Is Mr. Khinte, no? Mr. Khinte?
Lordship.
Anything else?
Yes, Your Lordship. In the earlier occasion, I have raised.
You have argued in detail on the other day, and you have submitted few case laws.
My lord.
To show that the provisions of section 52 and all has to be complied with, correct?
Right. Not only section 52, my lord.
Please adjust the microphone. It's very difficult for me to understand what you all are saying.
Lordship.
Yes.
Not only the section 52,
Yeah.
the rules made thereunder has also.
There is
been,
some issue with the volume. I'm not be able to hear you all properly.
Lordship.
Yes.
My submission is that not only the section 52, but the rules made thereunder has also been.
There is some difficulty in the network.
Am I audible, my lord?
Mr. Khinte and Miss Linda, do one thing.
Yes,
It is
madam.
very difficult to understand what you both have submitted. So
Okay.
just submit a small written note,
Yes,
and
madam.
I'll dispose this case on Monday. Just put submit it to the court master there. Is there any court master in the court right now at Aigal?
Yes, madam.
You give it to him and ask him to email it to my private secretary.
All right.
All right, both of you submitted on Monday. It will be the judgment will be given at 2 o'clock. So I'm reposting the matter on Monday at 2.
All right, madam.
Miss Linda, those whatever you have submitted based on your study of the case diary, just put that.
Yes,
And in
madam.
fact, those two decisions which Mr. Khempe you had relied is also not part of the documents that are made available to me. So I will request you to put whatever you want to put in your note. All right. You may not have to give the entire judgment, but the extractor, the paragraph that you are relying, you may just quote it.
If I may be allowed to submit some citations also.
Yes, you submit whatever you have to submit.
All right, madam.
Due to network issue, the hearing could not be concluded on the key mode in the video conferencing mode. Stop. Release this matter on Monday. So and so date.
Obliged.
At 2. In the meantime, parties are directed to submit written synopsis.
Pleadings are complete matter. Let it come after the vacation.
All right, but why the matter was for orders today?
Lordship, we already have filed
filed?
our yes, Lordship,
All
and
right,
the reply also has
okay,
been
heard Mr. This is item
47.
47,
heard
Lordship.
Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr.
P.N. Sharma.
K.N.
P.N.
P.N. Sharma, Learned Counsel for the petitioner. Stop. Also heard M.S.M. Bhattacharjee, Learned Additional Senior Government Advocate for the state respondent.
Oh, actually, on last occasion, they didn't appear, Lordship.
It appears
69.
that the pleading. Oh.
That's the reason, Lordship.
Yes. It appears that due to non-appearance of the learned counsel appearing on behalf of the petitioner on the last date, i.e. 16/9/2024, this matter was directed to be listed today with remark within quotes for dismissal in the order column. Stop. However, today when the matter was listed, Mr. R.P. Sharma, Learned Senior Counsel, is present. Stop. In view of the same, let this matter be listed for
Admission matter after the vacation.
admission.
Yes.
For admission,
Admission hearing, Lordship.
Pleadings are complete.
after 3 weeks on a date to be fixed by the registry. 48 also dismissal.
Lordship.
Non-appearance.
Same order here also, huh? After 3 weeks. Your name?
Hiraj Kumar Kolita.
Huh?
Hiraj Kumar Kolita.
D. Kalita.
D Kolita.
Here it will be D. Kalita. Okay. Other everything same.
Obliged, your Lordship.
49 also dismissal.
Yes, Lordship.
Why matters have to be listed with the remark for dismissal to ensure appearance of the petitioner's counsel?
I'm very sorry, Your Lordship.
All right, same order. Your name?
It's Borgoya.
I.H. Borbhuya. Huh? And
CKS Borgoya.
C.K.S. Borwa for the respondents.
Apply.
May I please, your lordship? As per office note dated lordship 18/9/24, service report is awaited.
Take just one sec. Okay, in the second two matters, see if it is for admission of a hearing. Huh? Just see that before you write. Or I'll ask. Good job. If we saw because the dismissal is yes, order indicates neither AD card unserved notice R1.
I
I am appearing for the respondent number 3 here.
3. What about R1?
Provisional report is awaited, Lords.
Awaited. Await service report in respect of respondent number 1. List after 3 weeks on a date to be fixed by the registry. Contempt. Service not complete.
We have taken steps, my lord.
So await service. Await service list after 4 weeks on a date to be fixed by the registry.
No, that date will be fixed, my lord. Right. My lord,
Yes.
I'm being led by Mr. Indranil Chaudhary, my lord.
Huh?
I'm being led by Mr. Indranil Chaudhary. My lord. He's on leg now. Will be taken up.
Order matter.
Oh, the order in question has been complied with, my lord. That it be, let him come. The contempt.
Is the order complied
Yes,
or not
yes, we've
complied?
complied. The payments have been made, my lord.
One second. Mr. Dasgupta?
No, their payments, they have deposited the amount in the registry, Milord. Actually, what amount they have deposited, I don't know.
So then I will, you have.
I have the.
You give it.
Yes.
You give it to him. He should be satisfied.
Anyway, Milord, the amount which has been deposited to the High Court registry, can it be deposited to his account?
No, this is a contempt case, Mr. Counsel.
No, this is my Mr. Chaudhary told me that he would make.
You will do whatever you will do. It is a contempt case.
No, your lordship would not understand, Milord. What I want to say is the amount that has been deposited to High Court registry, can it be deposited to his account? Because his marriage, daughter's marriage will be sometime within few days.
You could probably find the middle ground somewhere, my lord. In
All
some
right.
time, my lord.
His
Let
daughter's
Mr.
marriage
Chaud-
will be so.
All right, let Mr. Chaudhary be here.
Deeply.
So I requested him.
Sometime. Whenever Mr. Chaudhary is here, Mr. Dasgupta, Mr. Chaudhary, you inform the registrar. Yes, Mr. Das.
Meet please, Lord.
What is this?
Matter, my lord, we have included respondent number 6, my lord, in the last occasion. Perhaps, my lord, we have to take steps upon the respondent number 6. to
Newly
register
impleted, you have not taken steps.
No,
No
last-
notice was issued.
No.
It appears, let notice be issued to the newly impleted respondent number 6 by registered post.
Registered post, my lord.
By registered post AD. Steps to be taken within a period of 3 days from today. List after 4 weeks on a date to be fixed by the
He has
registry.
appeared for respondent number 125.
Hmm?
Respondent number 125.
That's all right. You want a name? On top, you say heard Mr. S. Das, Learned Counsel for the petitioner's top. Also heard Mr. I. Bothakur, Learned Counsel, appearing for respondent numbers
125.
125.
Highly obliged, my lord.
I generally avoid unnecessarily writing this in the order matters because you see the steno gets very burdened unnecessarily. Order matters. Your names are already there. Yes. Yes, 55 transfer, Mr.
Yes, ma'am. Lord, by way of this IM, we are praying for vacating the interim order granted to the writ petitioner. my lord.
Mr. Bhumik, you are the petitioner.
Yes. There is an interim order in my favor.
Transfer.
Transfer.
And you are?
My lord, respondent number 4 in writ petition.
No, you are the private respondent.
Yeah.
Yes.
What vacation letter? This matter could have been taken up for hearing only. Has the returns been filed in the main petition?
The state
Yes.
has not filed.
As far as we are concerned, Lordship, our instruction is still awaited, Lordship.
They are the main party here. How the private party respondent is seeking for a vacation of a transfer order?
My lord, there is an, my lord, option, the paragraph 8. Since this order has been passed ex parte quo, the respondent number 4, the said respondent number 4 may come up for modification if so advised. My lord, following this order, we are before this honorable court.
Yes, what to be done, Mr. Bhumik?
My lord, the petitioner is at the fag end of her service career. As on date, she has only 6 months to go. And it is no longer res integra that a government servant at the fag end of one's career ought not to be transferred. That is the law. And she has only 6 months to go. And that apart, the respondent number 4 has made a statement that I have made misleading facts, that I am a permanent resident of Guwahati, and from Golaghat I have been sent to Tezpur,
and pays to risk much closer to Guwahati than Golaghat. But that is not so. The petitioner is a permanent resident of Dhemaji.
Where is the order, stay order?
Lordship, page 16, IA. Sorry, my lord. Stay order, page 11, my lord.
No, you're right. 15, I think. In the IA.
Yes.
15, right? And the 16 it starts.
Lord, page 11 is the
In
transfer.
fact, the transfer was state considering the submission which Mr. Bhumik has just made,
Lordship.
that the date of superannuation of the petitioner is on 31/3/25. The impugn order of is suspended till the returnable date. Since this order has been passed ex parte, all right, that has been given, but this court is not inclined to modify at this stage.
Lordship.
So I can reject your application right now, or should I place this application along with the writ petition to be heard together?
My lord, along with the writ petition, it may be heard.
Yes, in the writ petition, who is appearing? Main respondents. Mr. Dhar,
Yes,
what about the return? When do you intend to file the return?
my lord, I have received a very small narrow comment. So
You file it
I will file, my lord.
next week?
Yes, next week.
So I'll say within 10 days you'll file it. In the remainder, you'll write both together. In the writ petition, you write, huh? Mr. Ardhar, learned standing counsel, you're appearing as standing counsel.
Yeah.
Mr. Dhar, you're appearing as standing counsel or additional senior government advocate?
Addition.
Additional senior government advocate for the state respondent submits that he has received the parawise comments and he shall shortly file the return in the matter. Stop. In view of the aforesaid assurance made by Mr. Ardhar, Learned State Council, list this matter after 10 days on a date to be, after 10 days date review on such and such date. On 3/10/2024. Stop. In the IA use and then list accordingly. In the IA, in view of the assurance made by the Learned State Council in the writ, in the accompanying writ petition, to the effect that the return shall be filed within a period of 10 days, the instant interlocutory application for modification of the stay order granted by order dated 38/2024 shall also be taken up along with the writ petition together, and an endeavor on that day shall be made to dispose of this writ petition.
Lordship, the interim order needs to be extended.
In the main.
In the main.
In the main, you say interim order passed earlier shall continue till the next date of listing. You put this in both IA and both, because I think at 2 to 6,
Yes.
3 might
Three
otherwise
might come in.
come in.
Yes.
In both, extended.
Obliged.
Obliged.
My lord,
Yes, Mr. Mahmood, why is this for orders?
this IA we have filed it for due to maximum urgency of the matter, my lord.
IA for interim relief,
IA
for
for
allowing
allowing the
appear.
yes, to file
Yes,
the
Mr.
examination.
Chaudhary?
Lordship.
My lord, Sunday, next Sunday, examination is scheduled.
No,
We
yes,
have-
I've understood. I'm just asking what is Mr. Chaudhary's response, first response.
Lordship,
If he
here,
concedes, I will dispose it of.
no, Lordship, they have not applied when the advertisement was there. Lordship, they ought to have applied, then only they can sit in the examination. On the basis of an earlier advertisement and examination, they are claiming for sitting in the written examination.
Yes, Mr. Mahmood,
My
what
lord,
do you have to say to that?
I am satisfying my. My lord, actually, we applied in the year 2022. There was advertisement, and that may be seen page 39, my lord.
Yes, then,
Then, my lord, this examination was cancelled
yes.
by giving a notice. Kindly see now page 57.
Yes.
That was cancelled. Thereafter,
57 where? In the petition,
57 of the writ petition.
report, writ petition.
57.
Yes.
So that was cancelled, my lord. Then we approached before the Honorable Chief Minister. The Chief Minister, there is a minutes of the meeting along with the Chief Minister that Lordship may kindly see. We have annexed that.
Page.
Yes, my lord. Page 42. Operative portion may be seen page 44. Clause 21.
Yes.
There could be
Are you
clause
claiming? Are you claiming a right on the basis of this minute?
minus, my lord. Now, my
Is
lord.
this minute been communicated to you?
Yes, communicated to you. That's why, my lord. What happened? Then, my lord, they issued the
No,
another advertisement.
where here it has been said
Page,
that
page 44, clause 21.
yes, there
There
could
could be a clause for relaxation of wage for those who had applied earlier. However, appointment order
This
will
is
be issued
about
only.
relaxation. However, appointment order will be issued.
Yes.
Yes.
As
So this is
relaxation.
relaxation
But thing
of
is
age.
this, when the present advertisement has been made, at that time we became over-aged.
No, but in that case, you'll have to make an application, Mr.
Yes.
Mahmood.
No, we-
Unless and until you make an application,
No,
how
earlier-
will they consider your case for relaxation?
No, my lord. Actually, earlier we filed another writ petition, and that writ petition was allowed. And asking that order I have also annexed here. Kindly see page 59, my lord.
Yes. Page
59. Operative portion may be seen.
Yes.
59.
Operating portion where?
Operative portion may be seen page 61.
61.
61.
61 it starts.
The most important, it starts from 59, but
63, para 10. The petitioners, except for so-and-so, should submit their applications.
Yes, we have submitted applications.
Applications for relaxation of their overage, along with a certified copy of this court. Thereafter, R3 shall take a decision on the same day by so-and-so. It is needless to add that if the petitioners are found eligible to participate in terms of notice advertisement so-and-so, the petitioner should be allowed to submit their application, candidature and admit card, allowed to submit their application, comma, candidature and admit card should be issued to them. So, did you file your application for relaxation?
Relaxation part is, we have filed application and it was said that you may sit in that interview and thereafter.
Mr. Mahmood, please don't complicate the answer. I am asking a simple question. In terms of paragraph 10, have you filed your application? And if yes, where is this application?
For as condemnation, we have not filed.
Then,
but we have filed in individual applications for allowing us to appear. Kindly see
Mr. Mahmood, it is your document, page 63 in your petition.
47, kindly see 47.
Before I go to 47, Mr. Mahmood, is this decision, the document at page 63, not a document enclosed in the writ petition? Yes. Now, what does para 10 says? It is a decision of this court. It clearly says the petitioners, except for petitioners number 2 and 7, should submit their applications for relaxation. Correct? Now, you have not done that, and you have filed an interlocutory application to allow you to sit in the exam. First of all, you have not filed the application in terms of the court's order. How can the respondent be blamed for not relaxing the age as decided in that minute? And how can now this court allow you a prayer to sit in the exam?
Actually, my lord, that was allowed. Kindly see page 16.
This is the short case, Mr. Chaudhary. Have I missed
16,
anything?
Page 16, my lord. Page 16, bottom, kindly see.
Page?
Page 16, bottom. All of us filed petition, page 16, bottom, but one of the earlier writ petitioner, particularly the petition number
Page
5.
16 of?
Page 16 of writ petition.
That Yes, what is this document, page 16? This is your averments.
No, this is my averments made in the writ petition.
Huh?
Here, kindly see the bottom, 16 bottom.
Huh?
But one of the earlier writ petition, particularly the petition number 5, got the opportunity by order dated so and so, as he was within the post of the advertised department, namely Director of Economics and Statistics Department, but others were not considered as their posts were not available in the advertisement dated 25/3/23. So at that time, those posts were not available in that advertisement. But now the latest advertisement which they have made, we are within those posts which were sought for to file petitions. So we file petitions, but our petitions were not accepted because that advertisement did not cover our post. But here our post has covered. Now kindly come to IA. Here, page 11, now kindly see.
Page?
11.
Yes.
Here we are all graduates. So, page 11 kindly see, bachelor's degree. For bachelor's degree, there are matriculate also below, down below. Minimum qualification
All right,
required.
that is not required right now because I'm not deciding the merit.
Only our prayers should be allowed given the admit
Yes,
time.
I've heard you as regards your prayer. Yes,
Other
Mr.
than our life
Chaudhary.
will go, my lord. Further, we will get never any chance.
Mr. Chaudhary, it's a fact that they have not applied in terms of this court's order,
No,
right?
yes, my lord, and that was with regard to advertisement of 2022.
Yes.
And the next advertisement was issued on October 2023. If they are as submitted by my learned senior friend lordship, if the post they intend to apply, if that was advertising the latest advertisement, they ought to have applied for relaxation.
So there is no application, as on date for relaxation of age.
Yes,
correct?
lordship.
And where do I get these reference for the advertisement dates? The first date.
First date, lordship.
Are we currently concerned with the advertisement dated 31/10/2023?
Yes, madam.
31/10/2023.
Page 70, lordship.
Yes, page
70 of the rate.
70. And initially at 22, do you have that date?
That was on
15/3/22.
that was of
15/3/22.
no, lordship, 17/8/2022.
17.
69.
17.
7. Yes, 17/8/22.
That is the first.
That is the.
That is the first which was cancelled, isn't
Yeah,
it?
which was cancelled. At
And
that
then,
time,
and then the minutes, and after
Yes.
the minutes, there was one more advertisement.
yes.
Which one is that?
This is 31/10/23, page 70.
No. There are till now there are two advertisements or three advertisements.
Two, lordship. Lordship,
Third, Mr. M.U. Mahmood learned in the IA, huh?
may I point out, lordship, in terms of earlier court's order, 25/3/2022 advertisement is at page 40, lordship.
Page
40.
which advertisement?
25/3/2022.
That is the advertisement. Which one? Second one or first one?
That was cancelled.
That, no, that was given by the SLRC for page 40, 41.
All right,
lordship.
you indicate me the date later on.
Yes, ma'am.
Just take your seat right now. Heard Mr. M.U. Mahmood, learned counsel for the petitioner, stop. Also heard Mr. B. Chaudhary, learned standing counsel, SLRC.
Yes, ma'am.
And Mr. R. Dhor, learned additional senior government advocate for the state respondent. Stop. By way of this interlocutory application, the applicant is seeking direction to the respondent number 3 to issue admit cards to the applicants and allow them to sit in the written examination of class 3 within bracket degree level, which is going to be held on 29/9/2024. Stop. Mr. Mahmood, learned counsel for the applicant, submits that is the first advertisement here. Page
Last advertisement.
first.
Page 40, Lordship.
Page 40.
Yes, ma'am.
Submits that pursuant to an advertisement dated
25/3/22. That's
25/3/2022,
22.
comma, the petitioners applied for the post of
Various posts of
pursuant to the advertisement dated so and so for filling up 13,141 numbers of vacant grade 3 posts
right.
under different establishments stroke departments under the government of Assam, comma, the petitioners applied and subsequently the said advertisement was cancelled by the government. Stop.
No, this advertisement was not cancelled, Lordship. Earlier, the department-wise, there was an advertisement they applied. That was cancelled, Lordship.
Notice page 57 by which cancelled.
Wait.
57 of repetition.
One second. You delete that part and you say Mr. Mahmood so and so submits that the applicants be allowed to appear in the interview for grade 3 post which is going to be held on 29/9/2024 pursuant to advertisement dated 31/10/2023 in view of the minutes dated 12/2/2022 held between Chief Minister Assam and other departmental heads to the government of Assam. Stop. Per contra, Mr. Chaudhary submits that since the petitioner has not applied to the advertisement dated 31/10/2023, comma, there is no question whatsoever to allow the applicants to appear in the interview thereof. Stop. I have given my prudent consideration to the arguments made by the learned counsel for the parties and have perused the record materials available on record. Stop. It appears that pursuant to an advertisement issued on 15/3/2022 and 25/3/2022, the applicants had applied for the post mentioned thereof. However, the government has cancelled those advertisements by notice vide number SLRC-G-3/6/advertisement/2022/2022. Stop. It further appears that at that time the applicants were within age limit, but now they have become overage.
Yes,
Stop.
that is our main case.
It further appears that where is that order of this court you had just quite? Yes, I've got it.
That is page 59,
59.
operative portion 63.
The same set of applicants had approached.
Yes, madam.
It further appears that the applicants earlier had approached this court by way of WPC 4782 of 2022, wherein this court by order dated 27/7/2022 was pleased to direct that the petitioners, except for petitioners number 2 and 7, should submit their applications for relaxation of their overage to the respondent number 3, along with a certified copy of this order, along with a copy of the writ petition by 1/8/2022, comma. Whereafter, the respondent number 3 was directed to take a decision on the same by 12/8/2022. Stop. It further appears that this court had further clarified that if the petitioners are found eligible to participate in terms of the notice stroke advertisement number SLRC-G- Roman 3 stroke 6 stroke advertisement stroke 2022 stroke 2022, comma, the applicants should be allowed to submit their applications stroke candidature, and the respondents should issue admit cards to them. It appears that the applicants has not filed the application for relaxation of age in terms of the aforesaid order of this court. Stop. In view of the aforesaid, this court,
My lord, one. Page 16, bottom may be seen.
I have seen that, Mr. Mahmood. In view of the above, this court is of the opinion that Mr. B. Chaudhary, learned standing counsel, SLRC, is correct in his contention that until and unless an application is filed in pursuant to the advertisement in question, comma, there cannot be any direction to the applicants to appear in the ongoing examination as scheduled. Stop. As such, I do not find any merit in this interlocutory application. Stop. Accordingly, the application stands rejected.
Okay.
Sorry, Mr. Mahmood. Yes, Mr. Chaudhary, it looks like we
have already
complied.
Yes.
Now, Mr. Dasgupta was saying about some deposit.
What had happened was we had preferred a SLB that was due to come up 2 days, just 2 days after the matter was, this contempt matter was listed. So in the meantime, in abundant caution, what we had done was we deposited by way of a demand draft in the registry. Now, since the SLP has been dismissed, I have in fact spoken to my learned friend. Whichever option your lordship, they can either withdraw it from the registry,
Yes.
or else if the DD is given back to us, we can transfer it to his account.
That will be better
No,
because
I think since you have deposited before the registry, I will direct the registry to release it to them.
Absolutely.
Let the registry release it.
it will take some time.
Mr. Dasgupta,
No, do not drop. He is sitting there.
all that ends
Her
well.
his daughter's prize will surrender.
Huh?
His daughter.
How much time will registry take to send to you? Even it will take the same time for the registry to send it back to them. Isn't it?
Your lordship can even make it time bound if he is in a hurry.
No.
Your lordship can say that it should be released within a week.
All right, all right.
And
You
so far as
have,
item 53 is concerned, it has been fully complied with. We have transferred it to her account.
That's all right.
all right, just 1 second. 52 and 53, 2 matters, right?
Right.
So only one thing is, Lord. So I may be granted liberty to file necessary application if so required.
What liberty do you need? This is a contempt court. I do not understand why in a contempt court such directions are always asked for. You have the liberties. You need a liberty for filing something which is given to you by the law.
That is
Anyway,
true.
first 52, huh? So there will be 2 separate orders, I guess.
Right. In 52, I must clarify one more thing. So far as the DD is concerned, that was only with regard to the principal amount. So far as the interest is concerned, we have already transferred it to his account.
I don't think we need to
Yes.
put all this. Where is the order otherwise? The main
There is
order?
no such specific order.
Where is that page?
The order against which contempt is
Correct,
alleged,
correct.
it is at page 12.
Page 12.
Starts from 12,
Operating part
17.
17.
Paragraph 14 and 15.
to compute the monetary benefits payable to the writ petitioners in both the writ petition flowing from so this has been paid.
Computation we have done. So
And you have deposited it before the registry, correct?
the principal amount, the interest has already been credited to the account of the petition.
Principal amount is
Principal is in terms of paragraph 15.
According to us, the amount would be 53 lakhs 59,000.
I am not going into the amount, Mr. Rajgupta.
No, your lordship has not, but I have to place it.
No, but it is given
That is
here
my address in there.
upon the respondents to compute the monetary benefits. They have computed and they have now they have already
Yes,
released
they
the
have-
interest and they have deposited the principal amount. If you have further grievance, you can approach the.
That is the one.
So for that, you don't need a liberty, Mr. Rajgupta. That liberty, that right, you have it. Anyway, for your satisfaction, I will
That is
add it.
sufficient.
Yes.
Because I have to file an application.
Heard Mr. A. Das Gupta, Learned Senior Counsel, assisted by MS B. Das, Learned Counsel for the petitioner. Stop. Also heard Mr. Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. B. Chaudhary for the contemners. One contemner or contemner?
Yes.
One contemner for the contemner. Stop. By filing this petition under Section 11 and 12 of the Contempt of Court Act, read with Article 215 of the Constitution of India, comma, the petitioner has brought notice of this court as regards the alleged non-compliance of an order passed by this court on 9/2/2023 in WPC number 9114 of 2023 and also 9/2/2023, which was modified. What is this?
Page 12.
See, one order is 9/2 and also 19/4 and 19/4/2023 in WA 99 of 2023. Okay, stop. Councillors, please take your seat. It is submitted. No, it is submitted document. Mr. I. Chaudhary, Learned Senior Counsel, submits that in compliance of the court's order dated 9/2/2023, comma, the interest as directed under paragraph 15 of the said order has already been released to the petitioner. Stop. He further submits that the principal amount as directed under paragraph 14 of the said judgment upon being computed has been deposited before the registry of this court. Stop. Mr. A. Das Gupta accepts the same position, however, seeks a direction for release of the said principal amount deposited before the registry of this court in favor of the petitioner. Petitioners or petitioner?
Petitioner.
Petitioner. Petitioner. Stop. In view of the aforesaid endorsement made by the learned counsels for both sides, it appears that the order dated 9/2/2023, against which the instant contempt petition has been filed, stands compliant. And accordingly, nothing survives for adjudication in the instant contempt petition. Stop. As such, the contempt petition stands closed. Let registry release the principal amount as deposited by the contemner in favor of the petitioner within a period of 10 days from today. So, you want to substantiate with anything? You have a document about on which date you have deposited?
On the
or
same
amount?
day as the order was passed.
Is there something? Please give. I just added in the order. And then you say it is needless to be clarified that in the event the petitioner is not in the event the petitioner is aggrieved with the quantum of the principal amount as computed by the respondents, comma, they shall be at liberty to approach the appropriate forum in law. Then I will, this is the amount, right? 2861,321. Mr. Chaudhary, that is the amount. So I can,
If necessary,
if necessary,
otherwise it's
8%, like detail. Huh? Achha, the other matter?
other matter, it has been fully
53?
complied with.
The amount to put the amount.
It has been, principal as well as the interest has already been transferred to the petitioner's account.
Otherwise, this is also against the same order.
Same order.
So everything remains the same, except here everything has been released.
Yes.
So
It was released on
same hoga,
11/9.
खाली AI Chaudhary जो submission होगा, that होगा, that the entire amount in terms of the
11/9/24.
order dated the same order so and so has already been released to the petitioner. Mr. Das Gupta agrees to the aforesaid submission, and then in view of the aforesaid error, nothing survives into paragraph as add kore diba. Baki khini aur na lage, huh? Stands closed.
Same observation.
Why? All right. For your satisfaction.
Not much is essential.
What disposed of? Did I mong hello baba? All right.
Much of this. Otherwise, I have to say problem is ever good.
Yes.
My lord, the respondents
Partha,
are
transfer.
issue, my lord. There was a status quo order passed in view of the
Today
fact
this
that
has come for orders.
today it has come for orders.
Lordship, we have not received the instruction. From the department.
So you want some time.
Yes, my lordship.
How much time?
2 weeks after vacation.
My lord,
As prayed for by MS
A. Sharma,
A. Sharma,
on behalf of B. Chakraborty.
Learned Counsel appearing on behalf of Mr.
B. Chakraborty.
B. Chakraborty,
CGC.
Learned CGC, comma, let this matter be listed after 2 weeks on a date to be fixed by the registry to enable the respondent to file return in the matter.
my lord, the status quo should be, there's a status quo till today, my lord.
Interim order, if any, shall continue till the next date of listing.
If
Yes.
May I please, your lordship.
Steps.
My lord, here in this case, lordship, my contempt petition was dismissed for non-prosecution on 31/3.
That is all right, but there, what happened to the service? The office note indicates steps for service of notice not yet undertaken by petitioner.
Lordship, the situation is that, lordship, in the meantime, all the contempt are already not in office, lordship. So I have filed 3 IS, lordship.
Where are those?
Lordship, 3 IS, lordship, for impediment, condonation, and lordship, restoration petition. So without implementing the new incumbent, lordship, I am unable to take steps upon the new incumbent.
So which one has to be taken today for condonation?
For condonation, lordship.
Yes, in the condonation only the steps is not complete.
No, in the condonation, lordship, I have already, lordship, not taken steps because, lordship, they are not the party in the main contempt petition, lordship. So without impediment, lordship, perhaps, lordship, that will not be proper, lordship, for taking steps upon their resolution.
No, what about these respondents, opposite parties 1, 2, 3?
1, 2, 3.
Where have they gone?
Yes, lordship, they are the new incumbent.
1, 2, 3.
Yes, lordship.
Have you your impediment has been allowed?
No, lord.
Then how you have arrayed them as opposite parties
Because-
without your impediment being allowed?
Yes, lordship. That's why, lordship. Because
What? That's why,
the lordship, because I have filed all 3 petitions, lordship.
Mr. Counsel, how you have put them in a condonation application as respondents? By which order of this court they have been arrayed as respondents?
No.
Then you please look into it. It looks like it is defect. As prayed for, list this matter after 2 weeks on a date to be fixed by the registry. You please have a look at it and correct it, whatever is required to be done.
Yes.
Perhaps you will have to first file an I with the earlier set of respondents, wherein you will have to say that now you have to file a newly implemented and seek that condonation. You check
Lordship, my impeachment petition is there, Lord.
but there is a delay.
This is the problem, Lord.
Please verify and
Lordship, liberty, I will correct, Lordship. You anything
no,
different?
no,
that
you
liberty.
first verify. Next.
Please, Your Honor.
Yes.
Your Lordship, this I is for a direction from this Honorable Court to take steps on the respondent number 9 to 24 through respondent number
How
25.
this court will take steps?
No, we'll take steps. Your Lordship will direct us to take steps through the office of respondent number 25.
Yes, any objection?
25. 25 is apna, yeah.
We have up to 24.
Yes, 25.
Here we have 24 is the
Yes, who's 25?
The
You want
commissioner,
25?
the commissioner, Your Lordship, Food, Civil Supplies, Consumer
Where
Affairs,
is he in
and
the
Legal
arrayed
Metrology.
list? 25?
25. 25 has been arrayed, has been impleted subsequent to a notification. There is an order, Your Lordship, of this Honorable Court at page 31.
Commissioner of Food Civil Supplies.
Yes, and Legal Metrology. So
Yes,
two
Mr.
departments were merged.
It can be done. I'll allow it then.
In fact, Mr. C.S. Hazarika also appeared for respondent number 25 on the earlier occasion.
Yes.
Yes, sir.
Sanakata appeared also.
Yes, yes. Let's not invest much time on this matter at least.
It will be more if we are through respondent number 4, director matter. Because he is in the helm of the
No, respondent number 4, that post has been abolished. That is why we had to incorporate item number, respondent number 25.
All right,
That
Mr.
is the
Heard.
reason.
You are Mr.
M. Sharma.
M. Sharma.
Yes.
May I heard Mr. M. Sharma, Learned Counsel for the applicant stop. Also heard Ms. A. Talukdar, Learned Government Advocate, and Mr. Ardhar. You're also there? And Mr. Ardhar, Learned, Learned, but as Standing Counsel, Learned Standing Counsel, Tribal Affairs.
tribal affairs plain.
Affairs, right? Within bracket plain. And MS? And Mr. S. Bora, Standing Counsel, Beaches. By way of this application, comma, the applicant is seeking a direction for
Serving copies.
allowing them to serve the for effectuating the service of notice to the respondent numbers 9 to 24 in WPC number 4331 of 2023
Yes.
to be issued through respondent number 25 within bracket the Commissioner, Food, Civil Supplies, Consumer Affairs and Legal Metrology, Guwahati 781007, Assam, instead of respondent number 4 in WPC number 4331 of 2023. Stop. The prayer is not opposed by the respondents. It appears that
Page 30. Page 30 is the relevant notification.
30.
30. Yes, Your Lordship. Annexure A2. So that was not in our knowledge when the petition was filed. Then we understood that the department of respondent number 4 was merged and respondent number 25 came into place. So the direction which was initially given for the steps for the notices to be routed through respondent number 4, that could not be effectuated. And
it appears that though earlier by order dated 4/8/2023,
yes, Your Lordship, 4/8/2023,
comma, a direction was issued to effectuate notice to respondent numbers 9 to 24 through the
Director.
respondent number respondent number 4 within bracket Director of Food, Civil Supplies and Consumer Affairs.
Yes.
Stop. However, since the said office has merged
with the legal metrology or controller of legal metrology.
Where do I get that?
At page 30, Your Lordship.
Yes, I have page 30.
The second line.
Okay, okay. Has merged with the Office of the Controller of Legal Metrology,
Yes.
comma, it has become essential to effectuate the said service of notice to the said respondents through the Commissioner of Food Civil Supplies, Consumer Affairs and Legal Metrology. Accordingly, the prayer is allowed. Let notice to the respondent numbers 9 to 24 be served through the office of the respondent number 25 within bracket so and so.
Extra copy may be sent.
The order of this court
Filing and
is it required to modify that order? Not required.
No.
Disposed of, huh?
Date to your lordship.
Yes.
Look, we have filed this IA in this pending petition. Now, if your lordship kindly takes the IA, my lord, I'll just give a background of this case, my lord. Now, this petitioner before a lordship, she is an ACS officer. Sorry, Assam Land and Revenue Service. Now, my lord, she was selected, she was appointed.
This IA is for what? For
IA is for, my lord, in spite of the fact that division bench of this honorable court has upheld my caste certificate. Now, my lord, they have again instituted an inquiry.
Inquiry.
Again. That is
So
right.
you want stay.
Yes.
You want
Stay of the.
And in this writ petition, otherwise, what have you challenged?
No, in the writ petition, we have challenged earlier notices, subsequent inquiry. Another inquiry has.
And those inquiry had been taken up before the division bench.
No. I'll give the facts, my lord. I joined this service. Then, my lord, my estranged husband, he used to file complaints and all. Based on that, eventually, my lord, my caste certificate was cancelled. Then I moved the learned single judge. Now, before the learned single judge, it so transpired that the, my lord, vigilance officer, which report is the, most vital, it has indicated that there is nothing wrong. Accepting that report, my lord, the learned single judge allowed my writ petition.
And that was taken up before
Then,
the DB.
against that,
which upheld the
writ
single
appeal
judge.
is preferred. My lord, that paragraph in the writ appeal judgment is very important.
Now again, a second time an inquiry.
No, during the currency of the order, my lord. Now, what had happened? Division bench has dealt with the issue.
Page?
I'll just refer. Please come to page 44.
Yes.
Testing the report of the vigilance officer, that is Inspector CID, on the touchstone of principles laid down in the case of Kumari Madhuri Patel, we find that the inquiry report submitted by the Inspector CID does not indicate even in the slightest that the particulars given by the candidate were false or that the social status certificate had been fraudulently obtained. Thus, in terms of the first part of para 13.7 of the guidelines formulated in Kumari Madhuri Patel, which provides that in case the report is in favor of the candidate and found to be genuine and true,
No further action.
no further action needs to be taken. No further action was called for in the present case after detailed and reasoned inquiry report had been submitted by the inquiry officer. However, state level scrutiny committee got another parallel inquiry conducted through Circle Officer Jorhat Revenue Circle, who apparently had no jurisdiction to carry out such inquiry as indicated above. Another significant fact which needs to be noticed is that as the report of the Inspector CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patel, did not give any indication that social status certificate was obtained by respondent petitioner by providing any false or fraudulent information, rather concluded that the social status certificate was validly and lawfully obtained. The authorities had no option but to accept the report and affirm the social status certificate of the respondent writ petitioner as per the guidelines contained in paragraph so and so. Hence, contrary conclusion drawn by the state level committee is absolutely illegal and unwarranted. As a consequence of the above direction, whereof the firm opinion that learned single judge was perfectly justified in accepting the writ petition filed by respondent number 1 herein and quashing the speaking order dated 26 to 21 passed by the state level scrutiny committee and affirming the social status of respondent number 1 herein as quotes. Thus, the impugned order does not suffer from any infirmity, and as a consequence, writ appeal fails and the same is dismissed as being devoid of merit. Well, against this a review file, review also dismissed. Now, my lord, what they have done, please come to that impugned show cause notice, my lord. Page number 58.
Yes.
Whereas SLC in its meeting held on 25/7/24 had requested Directorate
This
of
is after the DB's order.
after the DB's order, my lord.
Yes.
To initiate a Denovo inquiry, this office requested the Superintendent of Police CID to conduct an inquiry by letter dated so and so in pursuance of the guidelines issued for this purpose. Whereas Superintendent of Police CID by his communication has submitted the inquiry report on the status of your caste certificate as wrongly falsely claimed after investigation was carried by inquiry officer Sri Moromidas so and so. Whereas in pursuance of the directive of the Supreme Court, case Kumari Madhuri Patel, dated so and so, Government of
I
Assam.
can't understand the second paragraph.
Whereas
does
the
it say?
superintendent,
Yes. What does it mean? Has submitted the inquiry report on the status of your caste certificate as
wrongfully falsely claimed.
Who has given this?
I don't know, madam.
And this is after the DB.
After the division bench judgment.
The DB order, I thought, has closed the matter.
Exactly. That's our case also. That is our understanding also. And my lord, this review in the writ appeal judgment, it continued for not less than 6-7 hearings. Eventually, state withdrew it because division bench was not inclined to proceed.
You are seeking stay of this particular
Yes,
document
yes,
at page.
yes,
Yes, Mr. Nath. Why second time this inquiry? I'll come back to you, Mr. Chaudhary. If required.
In a case of caste verification issue, we have filed a detailed affidavit in the matter. I'll take your lordship to one paragraph of the affidavit in opposition. Kindly come to para 22.
No, but my understanding, subject to your correction, as
Lord.
far as that Kumari Madhuri Patel's case, that is only to ensure that false claims are not done, right?
Lord.
So the inquiry is limited to only that question.
Lord,
Now it appears that one inquiry was undertaken,
Lord.
and at that time, after verification and everything, it was found that there is nothing wrong, and accordingly, then how again?
Exactly in this case, Lord, what has happened? The inquiry which was held in 2019, but that was found to be a fraudulent inquiry. Lord, that inquiry was not proper. In fact, in kindly in a
Have
detail
you put all this before the petitioner? Has the petitioner been given any opportunity?
that is what the notice is given to him. It's given to the petitioner. In this notice, kindly see the inquiry report has been annexed. At page 58 is the notice, and the page 59 the inquiry report is there.
Page 50?
Page 59 of the IA. Page 59 is the IA. How that inquiry report of the earlier inquiry officer was found to be wrong, that is there, my lord.
So what steps have you taken against those officers who had earlier done the inquiry?
Departmental action has been taken in our affidavit. We have stated, my lord. Departmental action has been taken. He has made a perfunctory inquiry, my lord, without verifying. My lord, in Kumari Madhuri Patil's, there are some parameters given for making an inquiry that he has not followed. All
right, let's read this page 59.
Yes, page 59. This is addressed to the special superior police CID. After a detailed inquiry, verification and examination of documents, records, etc. pertaining to the matter in Jorhat, Golaghat, and Guwahati, I would like to submit here with the following: Srimati Monsoon Borkakoti, daughter of so and so, Santanu Borkakoti, and Srimati Purnima Datta, who was born at Sekonidhara Gao, is currently residing at Sekonidhara Gao, number so and so. Her father, Dr. Santanu Borkakoti, is a retired medical officer appointed to Class 1 cadre of Health and Family Welfare Department, Government of Assam, and is residing at the same place with his wife and children. Her mother, Srimati Purnima Datta, who is also a government employee, is currently working in the Irrigation Department of the Government of Assam as senior assistant,
Dr. Shantanu Borkakoti was born and brought up in Guwahati, Chandrabala Borua Land near SBI Evening Branch, Silpukuri. His ancestral roots belong to Betioni Kakoti Gaon, post office Betioni Moza Dhekial, district Golaghat. Sri Torun Chandra Hazarika, the village headman of Betioni Kakoti Gaon, confirmed that the great-grandfather of Dr. Shantanu Borkakoti was late Jagannath Kakoti, who shifted his residence to Guwahati. His son was late Shiva Prasad Kakoti, and Dr. Shantanu Borkakoti was the son of late Shiva Prasad Kakoti. Srimati Monsoon Borkakoti is the daughter of Dr. Shantanu Borkakoti, and they belong to Kolita community, which is a general category. Late Jagannath Kakoti's brother, late Pushpa Kakoti's family still resides in Betioni Kakoti
First, you are now showing me this detailed inquiry report, right?
Lots.
But what led you to do this inquiry? Where are those accounts?
Lots.
What has happened? Why?
In fact, what has happened after the division bench order, the subsequently there was an order passed by the Honorable Court to reinstate the petitioner in her service. While that process was initiated by the department, in fact, a detailed affidavit was filed in that case, and we have also indicated in the affidavit in opposition that if logic kindly comes to our affidavit in opposition, I'll indicate paragraph 4, paragraph 4 of the affidavit, page 222.
Your affidavit is
affidavit in opposition is a writ petition.
A writ petition. Yes.
It starts at page 221. 221.
Yes.
Paragraph 4, we have
Roman 4.
Paragraph 4, Roman 1 to I have indicated
what is the background. 4 at 2 to 5.
2 to 5.
Yes.
Yes, 2 to 5.
Read.
Logic. Pursuant to the Honorable Court order dated 24/11/2022, passed in WPC number 2286 of 21, and subsequent order dated 17/2/23, passed in WPC number 682 of 23. Here, reinstatement was directed. The matter relating to the service of the petitioner is under consideration of the higher authority in the government. The authority have explored the available legal remedies against the order dated 24/11/22, passed in WPC number so and obtained legal opinion as regards service of the petitioner, and follow up action have been taken in view of the Honorable Court order as mentioned above.
This paragraph, Mr. Nath, appears to be very contemptuous. How can this officer be expressing his displeasure over a report which was already held to be valid by the division bench of this court?
With all respect.
Are you following what I am saying?
That's true.
You see the word. I do not know what has happened, but you see the words. What is this? It says that in the legal opinion, displeasure has been expressed as regard the manner in which the caste verification report dated 21/10/2019 was submitted by the CID Assam on the basis of the inquiry report dated 3/10/2019 submitted by the inspector of CID. This is what is been affirmed, isn't it? How can this displeasure now be shown?
This inquiry report is here.
I could have understood if somebody brought something because of which you have come to a finding that something grossly wrong has happened and you want to do an inquiry. One could have understood, but what is this displeasure business?
The inquiry report is annexed here. It is there. I'll take your lordship to that also.
So, Mr. Nath, please understand. It is not open for you and me now to look into that inquiry report and see if that inquiry report is correct or not correct. The division bench of this court has already looked into it and have sealed the matter. If you are unhappy, go before the apex court.
Exactly. The report was.
Are you following what I'm saying?
Yes.
Because that is why I was asking you what was the basis for you to do this second inquiry. You are now showing me Roman 4, which this court does not accept. This court is not going to accept this explanation. This appears to be contemptuous.
In fact, in detail we have stated. This is the beginning. We have in detail
under what circumstances ultimately the second inquiry
Your
report has come.
affidavit is what? This is the averment on oath, Mr. Nath.
True. And this
cannot-
is the already it is on.
This
it
is
before
how
law.
can you relook into the inquiry report which this court both single bench
Malad-
and the division bench
Malad-
has
Malad, it is
upheld.
Malad, from the report. If Lordship goes to the report and ultimately considers Malad, it will reveal Malad that the report was.
I am not going to that far right now, Mr. Nath.
Malad,
You understand why I am
I-
not going?
I-
Because the division bench has already looked into it. You have any grievance, go to the appellate forum.
And review
Who
dismiss.
has stopped you to
no,
go before the
review,
apex court?
review was withdrawn. Malad.
Let's
Review
not
was
go
withdrawn.
into the review right now.
Lordship.
You admit that this inquiry report, which was challenged before the single bench and the division bench, it has been upheld.
It was considered.
Correct?
It was considered.
Yes.
Lordship.
Then where is the who is this legal author? How such a legal opinion can be given?
Malad, Lordship may.
Displeasure.
Lordship may.
Who is it to look into the inquiry report which has been upheld by the division bench of this
Malad,
court?
there are
Is
materials.
he higher than the High Court?
No,
Then-
not at all. Malad, Lordship may.
See, I am only on that, Mr. Na.
Man,
You understand what I am saying?
Malad,
This does not
I
look good.
I got it.
I am not saying that this is right, wrong. I'm not on the merit
Sure.
also.
Got it.
There could be a situation where a second inquiry may be required in the context of a particular case.
Lordship.
But there are certain ways in which a
Yes.
state has to function.
True.
The state cannot function in this manner.
Malad, when the fraud was found that inquiry report was not proper and the entire materials were not raised before a Lordship, Malad, then the review petition was filed and during course of the review petition, Malad, it was
I am staying the notice right now.
Malad, my request
Sorry,
is Malad,
I can go. I can give you a detailed order and take necessary actions also. I can. But right now, I don't want to get into all
Malad,
this.
Malad,
It appears
Malad,
that the SOCAS notice which has been issued
Malad, my request
is in total violation
Malad, I have
of the orders passed by this court.
Malad, I have a
Anyway,
humble prayer, Malad. I have a humble prayer, Malad. Malad, we have filed the detailed affidavit is on record, Malad. Let the IAB here, Malad, and Lordship may kindly fix the matter on 30th, Malad.
Paragraph 4 is already there, which indicates.
Yes, Malad.
So,
we have
anyway,
filed our affidavit.
sorry,
they have
Mr.
filed their
Nath.
reply. Lordship may kindly fix the
No,
matter on
I am
30th,
not
Malad.
giving you more time in this matter.
Kindly give us a date, Malad,
sorry.
for consideration of the matter.
Heard Mr. K.N. Chaudhary, Learned Counsel, Learned Senior Counsel, assisted by Mr. J. Patwari, Learned Counsel for the petition applicants. Stop. Also heard Mr. D. Nath, Learned Senior Government Advocate for the state respondent. Stop. By way of this interlocutory application filed under Section 151 of Civil Procedure Code 1908, the applicant is seeking direction for restraining the state authorities from giving effect to the impugned show-cause notice dated 2/9/2024 issued by the Director of Welfare of SC and BC Assam. Stop. It appears the facts of the case is that. Which paragraph, Mr. Patwari, the facts are?
Yes. Judgment, my lord.
No, where in your IA?
Yes. Page 44, para 15.
All right. The applicant, though her father belonged to general category, was born and raised in the ancestral home of her mother, who belongs to Kush community within bracket OBC. And having adopted the rituals and customs of her mother's community, comma, she suffered from disadvantages while growing up, and and later on, while she was studying in class 9 in the year 2006, upon her mother applying for a caste certificate, an OBC certificate dated 13/11/2006 was issued. Stop. Mr. Anat, take your seat.
Lordship. Just
Take your seat. You later on you may.
I'll indicate.
Later on, the applicant, pursuant to a selection process held by the APSC, was appointed to the post of Assam Land and Revenue Service within bracket junior grade on 9/1/2019 as an OBC candidate. Thereafter, the applicant was posted as circle officer within bracket attached, Margarita, in the district of Tinsukia. Stop. It is the further case of the applicant that upon a complaint being filed by a anti-corruption liberation union alleging that the father of the applicant is a general category candidate, and as such the certificate obtained by the mother of the applicant is not genuine, the state level scrutiny committee under the erstwhile Welfare of Plain Tribes and Backward Class Department, Government of Assam, held an inquiry and by a speaking order dated 26/2/2021 arrived at a finding against the applicant and accordingly recommended cancellation of the said OBC caste certificate dated 13/11/2006. Being aggrieved by the aforesaid order of the SLSC, the applicant filed a writ petition before this court, being WPC number 2286 of 2021, wherein the legality and validity of the said speaking order dated 26/2/2021 was assailed. Stop. This court, after hearing the counsels for the parties, by order dated 31/3/2021, that 31/3 is an interim order.
Yes, my lord. 24/11.
Okay. Upon the aforesaid writ petition being moved, this court on 31/3/2021 was pleased to direct in the interim to the authorities not to take any coercive step against the applicant in terms of the aforesaid speaking order dated 26/2/2021. Stop. Upon the contesting parties being heard and perusal of the materials available on record, this court by order dated 24/11/2022 rendered its judgment, wherein this court was pleased to set aside and quash the speaking order dated 26/2/2021 of the state level scrutiny committee. Stop. Thereafter, the Anti-Corruption Liberation Union preferred an appeal before this court, being WA number 42 of 2023, challenging the aforesaid judgment and order dated 24/11/2022, which, upon being heard, the Honorable Division Bench, by judgment and order dated 1/6/2023, was pleased to upheld the legality and validity of the applicant's OBC caste certificate dated 13/11/2006 and the order of the learned single judge dated 24/11/2022. Stop. It further appears that the state authorities had also filed a review petition number 6 of 2024, assailing the legality and validity of the judgment and order dated 1/6/2023, passed in WA number 42 of 2023 before the Honorable Division Bench, however, when was the review dismissed?
Page 349. Page 349.
Page 10,
Page 349 is the order.
Page 10 is the recital. Paragraph.
Last ki likhi na?
Kindly see page 349.
Okay. Stop. Stop. Thereafter, the said review petition was withdrawn by the state authorities on 28/5/2024. Stop. Pursuant to the efforts thereafter, on 2/9/2024, a show cause notice was issued to the applicant, wherein the applicant has been intimated that the SLSE in its meeting held on 25/7/2024 has decided to initiate a Denovo inquiry as regards the status of the caste certificate issued to the applicant. Stop. Situated thus, the present interlocutory application has been filed seeking stay of the operation of the said show cause notice dated 2/9/2024. Stop. Mr. Ken Chaudhary, learned senior counsel, submits that pursuant to the single bench, pursuant to the single bench and the division bench of this court, having held the caste certificate issued to the applicant valid and having held the inquiry held by the inspector CID. Erroneous, comma, the issue as regards the caste certificate has attained finality unless and until the same is set aside by the apex court. Attain finality. Stop. He further submits that the inquiry report dated 3/10/2019 of the inspector of CID was also tested and upheld by the division bench. Stop. He further submits that once the issue of the caste certificate having attained finality and the inquiry report dated 3/10/2019 being tested and upheld by the division bench of this court, comma, it is not open for the respondent authorities to initiate a de novo inquiry into the same issue. Stop. Per contra, Mr. Dinath, learned senior government advocate, submits that an inquiry has been necessitated in terms of the legal opinion received in the matter, and he accordingly draws the attention of this court to para Roman 4 of the affidavit in opposition filed in the writ petition. Stop.
And para 22 also.
And para
22 also. No? Para 22. Page 236.
Page
36. No?
36.
36.
He further submits that de novo or fresh inquiry is permissible in case it is found that the earlier inquiry into the caste certificate is vitiated by fraud or when the same was issued without proper inquiry. Stop. I have given my prudent consideration to the arguments made by the learned counsels for the parties and have perused the material available on record. Stop. It appears that the caste certificate issued in favor of the applicant was cancelled by the SLSC by a speaking order dated 26/2/2021, which necessitated the petitioner to approach this court by way of WPC 2286 of 2021. Stop. It further appears that during the course of hearing of the writ petition, the learned that the state of Assam presented the original records before the court inter alia containing a report of inquiry conducted under supervision of Superintendent of Police CID, Assam, Guwahati, with regard to the OBC certificate of the respondent writ petitioner. The inquiry was conducted by the Inspector of Police CID Assam, and the inquiry report dated 3/10/2019 was submitted concluding that aspersion on the OBC certificate of the applicant was based on no truth. It further appears that placing reliance on the said report, the learned single judge, by order dated 24/11/2022, affirmed the findings of the inquiry officer in the report dated 3/10/2019 and set aside the speaking order dated 26/2/2021 issued by the SLSC. Stop. It further appears that thereafter, the Anti-Corruption Liberation Union preferred an appeal, being WA 42 of 2023, against the aforesaid judgment dated 26/2/2021, wherein the division bench of this court also, after testing the report of the vigilance officer, i.e. the Inspector CID, on the touchstone of the principles laid down in the case of Kumari Madhuri Patel, reported in just give it to my reported in so and so, held that the inquiry report submitted by the Inspector CID does not indicate even in the slightest that the particulars given by the candidate were false or that the social status certificate had been fraudulently obtained. Stop. Paragraph 15 and 16 of the aforesaid judgment of the division bench is reproduced hereunder for ready reference. Stop. Reading of the aforesaid observations of the division bench abundantly clarifies that both the learned single judge and the learned division bench of this court has affirmed the findings of the inquiry report dated 3/10/2019 of the Inspector CID. It appears that despite of the aforesaid orders of the division bench of this court, a show cause notice, the respondents have taken the decision to initiate a Denovo inquiry as regards the caste certificate of the applicant, on the basis of a legal opinion which is projected in paragraph Roman 4 of the affidavit in opposition. So, paragraph 4 of the said affidavit in opposition is reproduced herein for ready reference. Page 225 of Pamade. Agors into this to 15-16, it is 44 page. Reading of the aforesaid paragraph appears that it is averred. Who has filed this affidavit? No, who? By one Roop Kamal Rabha. Who is he? Who is one Roop Kamal Rabha, who is serving as Deputy Secretary to the Government of Assam Personnel within bracket A Department. That pursuant to the court's order dated 24/11/2022 passed in WPC 2286 of 21, and subsequent order dated 17/2/2023, passed in WPC number 682 of 2023, pertaining to the consideration of the service of the petitioner, comma, the authorities have explored the available legal remedies against the order dated 24/11/2022, passed in WPC 2286 of 2021, and obtained legal opinion as regards the service of the petitioner and follow-up action to be taken in view of the Honorable Court orders. Stop. It is further averred that in the legal opinion received, comma, displeasure within quotes has been expressed as regard the manner in which the caste verification report dated 21/10/19 was submitted by the CID Assam on the basis of the inquiry report dated 3/10/2019 submitted by the Inspector of CID, and also pointed out various issues, and it was suggested that the judgment passed in WPC number 2286/2021 and all subsequent orders requires to be challenged before the appellate forum. Stop. It appears that no appeal as regards the order of this, or as regards the order of the division bench dated division bench is dated
1/6/2023.
1/6/2023 has been filed by the state authorities. Stop. In fact, it appears that based on the aforesaid legal opinion, a decision has been taken for initiating Denovo inquiry, and accordingly the impugned show cause notice has been issued. Stop. It defies the logic of this court as how the respondent legal authority, legal officers could have expressed displeasure to the inquiry report dated 3/10/2019, which has been tested both by the single judge and by the division bench of this court, and has been found to be valid. Such conduct of the respondent appears to be contemptuous and cannot be taken lightly. The respondents are at liberty, if aggrieved, to approach the higher forums, but cannot be sitting and commenting on the orders passed by these courts. So, be that as it may, the show cause notice dated 2/9/2024 appears to be prima facie illegal, and as such, this court, where is the prayer?
Yes. Page number 13 of 12 mirror. Bottom.
Page number 12.
It starts at 12 and
I
IA mirror. And the relevant portion is at page 13.
I am
NXRG.
only concerned with this 2/9.
2/9.
States the operation of the show cause notice bearing number E312158/2023/15 dated 2/9/2024 till the pendency of WPC number 3125 of 2024.
Developed.
Application stands disposed of.
much of that.
Mr. Nath, your officers has to be careful with the words they choose. When an affidavit is presented before the court, these matters should not be taken lightly because very difficult days otherwise will be coming if such kind of words are being used in the affidavits. You see, we all are here to protect the institution.
Absolutely.
It cannot, such words should not be used. You have remedies.
I'll see.
Yes, next matter. please.
Here we go, Lordship. As per last order, we have taken steps on respondent number 6.
You have taken?
Yes, Lordship. We have taken steps, and today only we have filed IA for striking out the name of respondent number 2 and 3.
IA is there?
Yes, but I think
IA
it is
hasn't
not in
been
record, Lordship,
Oh, the IA is not on record.
because we have filed today
Okay,
only.
all right. Your name?
R. Shah.
MS R. Saha, learned counsel for the petitioner, submits that an IA has been filed today. However, the same is not on record. Let registry verify and place the same on and list the same on any day next week. Yes, Mr. Banik. Area dues.
No, it's okay. Not in the matter. We have taken steps in this matter, but for the order dated 38-2024, but for the order dated 38-2024, it's not been dispatched.
Huh?
It's not been dispatched
Not dispatched.
because when notice was issued,
I have not understood.
my lord, we
What
have
is
the
not
order
dispatched?
30th of
You are
August.
required to take steps for service upon R4.
Or it should be R5.
Huh?
It should be R5.
Oh, this has been by mistake, inadvertently
It should be
mentioned.
R5,
Huh.
and Ganguly was appearing for R6.
Okay.
That much, because the office, they say, since it's there in the order, we cannot dispatch these steps. So I thought, let the matter come, then we have it. The Lordship clarifies to that extent
Now, what do you want to do?
that A. Ganguly is appear for respondent number 6 and steps to be taken on respondent number 5.
You want this
That's
clarification.
clarification only.
But have you filed an IA?
We have not, that would complicate the matter because we are thinking of mediation. I
How
thought,
can I modify a judicial order without there being any
I understand.
IA?
On my submission, I'm clarifying that,
Mr. Banik,
or Lordship
very
records,
difficult.
or my Lord records that we had taken steps, but it's not being dispatched because of this. Accordingly, we'll file an IA. Let that be there.
Mr. S. Banik, learned counsel appearing for the petitioner, submits that though he has taken steps for service of notice upon the respondent number.
Let it be in terms of the order dated 38.
No, you first tell me. Respondent number
5.
5. However, the same could not be dispatched by the dispatch section of this court in view of the order dated 38/2024, wherein by inadvertently it is mentioned as respondent number 4.
It could not be dispatched from the section, concerned section.
Because of this order.
Because of this.
Dispatch because dispatch concerned section code. He accordingly. What will you do now?
I have to find I, otherwise it's okay.
He accordingly seeks some accommodation in the matter to do the needful. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry. See, judicial orders, unless there is an IA, even if it's my order also, I cannot. There are certain protocols.
For hearing, item number 58.
Lordship, I am praying for adjournment, Lordship.
Yes.
My senior is out of station, Lordship.
All right. Yes.
Lordship, since it's on a medical ground, we would not be objecting much to it. But the petitioner is
When do you want?
Very short date, next week.
Next week, Lordship. 26.
As prayed for by Mr.
DJ Boro, Lordship.
DJ Boro, learned counsel for the respondent on the ground that Mr. J.K. Goswami, who is handling the brief for the respondent, is indisposed today, let this matter be listed again for hearing. Give a date.
26.
On 26 9/2024. Yes,
Lordship, I filed my affidavit today, Lordship.
it has not come on record.
It has not come on record.
All right, Mr.
A. Bhattacharya, Lordship.
Mr. A. Bhattacharya, learned counsel for the petitioner, submits that an affidavit,
Affidavit,
Rejoinder.
additional affidavit, Lordship.
an additional affidavit has been filed today. Stop.
Yes.
However, the same is not on record. Let registry verify and place the same on record list.
Can this be after vacation?
List after 3 weeks on a date to be fixed by the registry.
Keep the